You got Bear Walker drums. Okay, I call a meeting tomorrow, to order, pardon me, call a meeting tomorrow. We're all going home after tonight. You got Bear Walker drums. I'm gonna ask, okay, I call a meeting tomorrow, to order, pardon me, call a meeting tomorrow. We're all going home after tonight. Okay, I call the meeting to order. I'm gonna call, I'm gonna Melissa. Gillis. Okay, I call to come and do the morning call the meeting tomorrow. Summary for yesterday night. And so we can start with that, so we freshen our minds what we discussed yesterday and as we move forward into today. My cell phone's ringing. Okay, anyway, Melissa, maybe you can come up and give an overview of day one. All right.
Good morning, everyone. Thank you to our drum group and this morning, yesterday, for their opening prayers to this 2 days. I'm just going to give you a brief overview. The summary will be, it's a more of a high-level overview of the day yesterday. And Bentley has told me yesterday and today, make it short, make it short. And now he just said to me, take your time. So, so I'm going to go through this really quickly. So day one of the Treaty Knowledge Keepers and Elders Gathering brought together our elders and knowledge keepers, leadership, legal experts, and participants to present or examine the history, interpretation, and contemporary relevance of treaty relationships. The gathering created space for the sharing of knowledge, legal perspectives, and lived experiences related to Treaty 9 and the broader treaty relationship with First Nations. Throughout the day, discussions reflected the importance of bringing together historical research, elders' knowledge, legal analysis, and international perspectives in order to better understand both the original intent of the treaties and the challenges surrounding their implementation today. The gathering opened with the Walking Bear drum group, followed by an opening prayer offered by Bentley Chichu, grounding the gathering and ceremony. Bentley also served as master of ceremonies, guiding participants throughout the day's program. Opening remarks were delivered by Deputy Grand Chief Metawabin, who welcomed the participants and emphasized the importance of ongoing dialogue amongst elders, knowledge keepers, leadership, and legal experts to deepen the understanding of treaty relationships. In his remarks, he reflected on the teachings passed down by elders and previous generations of leadership regarding the understanding reached at the time of treaty signing. He spoke about how these understandings emphasized that First Nations and peoples, including Cree and Ojibwe nations, were not to be restricted or confined, and that traditional livelihoods such as hunting and trapping were to continue. He noted the land was not understood through concepts of ownership, but through responsibilities as stewards of the land. He emphasized that the treaty represents an ongoing relationship that must be understood in the present day and revitalized through the renewed attention to how treaty principles inform such areas as governance, economic development, health, lands and resources, and fiscal relationships. Due to the change in the agenda, Luke Hunter's presentation was moved forward to the morning session. The presentation summaries of Luke Hunter Treaty Initiatives and Knowledge Preservation. Luke provided an overview of several initiatives that are underway to strengthen the documentation, preservation, and public understanding of Treaty 9 history and its continuing significance for First Nations. Luke highlighted 3 key initiatives currently being advanced. The first initiative involves the development of a treaty website for NAN that will serve as centralized platform for treaty history and archival materials and educational resources. The second initiative involves the documentation of our elders, interviews, and testimony, ensuring that the oral history and teachings relating to treaty understandings are preserved for future generations. And the third initiative concerns Treaty 9 commemoration, including work to recognize historical locations connected to the signing of the treaty and to support broader awareness of treaty history. Luke also raised several considerations for discussion with participants, including intellectual property and data sovereignty related to elders' testimony and how communities may wish to guide future Treaty 9 commemoration initiatives. This discussion raised some questions on how should elders' testimony and materials be preserved while respecting community ownership, intellectual property, and data sovereignty. Things to think about throughout the day today. Dr. Janet Armstrong did a presentation on simple terms of the treaty, impressions left by the commissioners. The presentation examined the historical records describing how treaty commissioners explained Treaty 9 to First Nations community at the time of signing. Drawing from archival documentations and commissioners' report, Armstrong outlined how First Nations leaders asked questions about whether signing the treaty would restrict their ability to hunt, fish, and trap. Historical accounts indicate the commissioners reassured communities that they would continue their traditional activities and would not be confined to reserves. Reserves were described as areas set aside for the use of benefit for First Nations communities, while traditional activities would continue across the broader territory. Armstrong emphasized the importance of examining both written records and oral histories when interpreting treaty agreements. Prior to the lunch, Elder Lucy Long-Peter offered a prayer and blessing over the meal, acknowledging the importance of gathering together and sharing this knowledge. The afternoon opened up with Amy Westland, High Impact Treaty Litigation presentation. Amy provided an overview of several major legal cases currently shaping the interpretation and implementation of treaty rights affecting Treaty 9 First Nations. Amy explained that courts increasingly play a continuing role in overseeing treaty implementation and may issue declarations requiring governments to negotiate where breaches of treaty obligations are found. Courts have also affirmed that provinces must participate in honorable treaty implementation and that compensation may be awarded where fiduciary duties related to treaty lands have been breached. The presentation reviewed several major legal actions currently before the courts, including litigation related to annuities, economic benefits, cumulative impacts on treaty harvesting rights, and governance authority over lands and resources in traditional territories. Several questions were raised at the time and by the elders, and how might the outcomes of these cases affect future treaty negotiations and governance discussions, and what risks exist if courts interpret treaty rights more narrowly in these cases. Adam Fiddler presented misunderstanding the treaty with reflections on compensation. Adam's presentation examined how modern interpretations of treaty agreements can differ from the understanding described in elders' teachings. Adam spoke about how elders often describe treaties as long-term relationships grounded in coexistence, shared responsibility, and mutual benefit. These teachings emphasize that treaties were intended to guide relationships between peoples rather than represent a simple transfer of land ownership. He encouraged participants to reflect on how modern discussions about compensation and legal settlements may influence how treaty relationships are understood. That brought up many discussions, and one of the questions that was raised was how can modern legal and policy discussions about compensation remain aligned with elders' teachings on the spirit and intent of the treaties? And what's the difference between the actual treaty written document and our elders' oral understanding? Next, Presenter was Ron Lehman, Treaties in the International Arena. Ron Lehman's presentation explored how treaty rights have been advanced through international advocacy and engagement with global institutions such as the United Nations. The presentation reviewed early efforts by First Nations leaders to bring treaty issues to international forums, including the work of the International Indian Treaty Council beginning in the 1970s. I only chuckle because I know Ron very well, and he kept saying that he uses that picture that was from the 1970s for his for his picture. These efforts helped establish international recognition that treaties between Indigenous nations and states represent binding agreements between the sovereign parties. Ron also discussed the significance of the UN DEC on the rights of Indigenous people, UNDRIP, which affirms the rights of Indigenous peoples to recognition and enforcement of treaties and agreements with the states. Questions that were raised during his discussion: how can international mechanisms such as UN bodies and UNDRIP strengthen the recognition and enforcement of treaty rights? Again, another big discussion that will carry forward to today. Mike Sherry was the next presenter, and I believe was the last. Legislative Developments, Bill 5 and Bill C5. Michael examined the recent provincial and federal legislation that may affect First Nations treaty rights, specifically Ontario's Bill 5 and the federal C5. Both statutes were introduced and passed in 2025 during a period of economic and political pressure related to international trade disruptions. The legislation was designed to accelerate infrastructure and resource development projects. Michael explained that these laws may allow governments to streamline regulatory processes and override existing legislation to expedite developmental projects. Many First Nations have raised concerns that these measures were adopted without meaningful consultation or efforts to obtain FPIC, or free and prior and informed consent. He emphasized that treaty rights protected under Section 35 of the Constitution 1982 remain constitutionally protected and cannot be overridden by ordinary legislations. This raised a few questions, including could the legislative powers created by Bill 5 and C5 withstand constitutional challenges related to treaty rights? And how might these laws affect future development projects in treaty territories? That was the end of the day of our presenters. Within the conclusion of the day, it concluded following the final presentations with participants reflecting on the knowledge shared throughout the day. And of course, the participants were invited to continue discussions during day 2 of the gathering.
Now, I'll call on Dr. Juicy. Juicy. I don't know how to pronounce the name. Juicy. Okay. To make a presentation on the AB line.
It's in the living room. I'm on Zoom.
Make the presentation.
Sorry. Zoom meeting.
Yeah, could you share the
Huh?
screen, please?
Thunder Bay Zoom. Knock. Zoom meeting.
Yeah, could you share the screen, please?
Thunder Bay Zoom. Knock.
Can you see the first slide?
Zoom meeting.
Yeah, could you share the screen, please?
Thunder Bay Zoom. Knock.
Can you see the first slide?
To meeting.
Yeah, could you share the screen, please?
Kan je bij Zoom? Knock.
Okay, you can see me, so can you see the first slide?
We
Can you
still
see the
can't
first
hear
slide?
you.
Yeah, could you share the screen, please?
Kan je bij Zoom? Knock.
Okay, you can see me, so can you see the first slide?
We still
Hey,
can't
Len,
hear
we
you.
see you, but there's a interruption there with somebody else speaking, so stand by.
Okay, I'll put up the first slide. Can you see it though? Okay, you can see me. Can you see the slide now?
We see you, but there's a interruption there with somebody else speaking, so stand.
Okay, I'll put up the first. Okay, you can see me. Can you see the slide now?
We see you, but there's a interruption there with somebody else speaking, so stand.
It seems like it's doubling, it's repeating. So you can see me now, right? So now you should, if you share the screen. Right, so if you share the screen, then I can put up the presentation.
Hi, good morning, Len. Go
Yeah.
ahead, share the go ahead and share your screen.
You have to share it. You have to share it with me.
Okay, hold on a sec.
Okay, you can start.
Okay, thank you. Hello, everyone. I'm Dr. Leonard Tucci, and I'll just be presenting on Treaty Number 9 and the issue of the AB line. So at Confederation in 1867, you can see that here, Ontario was just a fraction of its size that it is today. With both Treaty 9, you can see here, and its adhesions here, this became what we now know as Ontario. And these maps are based on official maps of the Government of Canada. Here, you can see what has become known as the line AB or the AB line. So you can see where the adhesions were and where Treaty 9 was. So in 1901, when they started to talk about getting a treaty for Northern Ontario, you can see that the area to be included in the treaty only came up to the Albany River. And originally, it included portions of Quebec, but this was later, for political reasons, this was left out of Treaty Number 9, and it would just be dealing with Ontario. So there was a lot of controversy has been associated with Treaty Number 9, and a lot of it has to do with that Treaty Number 9, it had as a commissioner Daniel G. McMartin, who was part of the government of Ontario. And the issue is that although the treaty was made between the federal government or the British Crown, which the federal government represented, it had to include the government of Ontario, it had to get concurrence. And so this caused a lot of issues. And the reason why there was a lot of issues here is that Ontario wanted different things in the treaty that weren't originally in the treaty. And so this caused some basically time delays. And it was one of the things where the actual making of the treaty was very haphazard. So on 30th June 1905, the commissioners went into the field. So there was Daniel G. McMartin, Government of Ontario. There's Duncan C. Scott and Samuel Stewart representing they were the other two treaty commissioners representing the Government of Canada. And so it must be remembered that when they went into the field with the treaty, there were no negotiations. And so if you read this, you can this section, and this is from the actual report of the commissioner's report by Scott et al. In 1905, that the terms of the treaty were fixed. So there's nothing that the commissioners could do to change what was already in the treaty. And this was because of the government of Ontario specified that there would be no negotiations. And I'll let you read this here, and then I'll talk about it. I'll give you just a minute to read it. So this is the actual text from Treaty Number 9, and it set out the boundaries. And so as you can see here, the boundaries, the northern boundaries, north by the boundaries of the said province of Ontario as defined by law. As defined by law, the northern boundary of Ontario at that time was the Albany River. Anything north of the Albany River was the Keewatin District or part of the Northwest Territories. And so remember, that the terms of the treaty were fixed when they went out, the commissioners went out. And not only that, you can see here, there's no mention of the line AB in the treaty text. And the treaty text is the official text in the common law of the country. And so remember back that when they actually went into the treaty, commissioners went in the field was on the 30th of June, 1905. So an order in council was passed, dated 6th of July, 1905, and this gave them, the treaty commissioners, permission to bring into treaty First Nation people north of the Albany River. But the problem with this is that the treaty commissioners were already out in the field. And since they're already out in the field, there was no way that they could get this information could get to them. Okay, because they're traveling by canoe and that there's no way to get this information that they now had permission to actually do this. And you also have to take into account that the treaty was, like I said earlier, the treaty terms of the treaty were fixed, right? And so there was nothing that they could do in reality to include the treaties in treaty the First Nation people north, because that's not what the text of Treaty 9 said, okay? But in the report that's D.C. Scott, who was the commissioner, it's the commissioner report afterwards in 1905, in their actual report, you can see here, this is in the quotations, that they said that they brought into treaty people lying to the north of the Albany River, which they did not have the authority to do because they never got news of the order in council. Plus, like I said earlier, you can't change the terms of the treaty because they were fixed. So 1913, you can see this is the diagram of unceded land in Ontario, and you can see it started at the boundary of the Albany River. And so Scott, when he's talking about in his, excuse me, in the report, he talks about, like I said earlier, what lies north of the direction of the Albany River, that was all ceded. And then later, for the people that were doing the adhesions to Treaty Number 9, Kane and Ari, they talk about the northern boundary of Treaty Number 9 was the line AB. And this is the one, this is the map I showed you earlier. So here's the AB line. And this is the officially from the official report of Kane and Audrey. And these were the ones that came later to do the adhesions to Treaty Number 9. And so going back to this map, you can see here, officially, this is what they're saying. Albany, up to the Albany River. This is Treaty 9. The adhesions is all the other areas. These are based on the official maps of the government of Canada. It wasn't until April 1st, 1912, that the northern boundary of Ontario was officially extended to what we think of as Ontario today. And this was by the Ontario Boundaries Extension Act. And I'll just let you read this, give you a minute to just read this. That was this passage that was taken from the adhesions to Treaty Number 9 in 1929. as you can see here, for the adhesion to Treaty Number 9, it says bounded on the south by the northerly limit of Treaty Number 9. And so what was the northerly limit of Treaty Number 9? Officially, by the official text, that would be the Albany River. And this just shows you. So this is what the adhesions would include. But we have the issue of the AB line, because this is what in the official commissioner's report for Treaty Number 9, 1905, this is what they said up to what was for the First Nations that they signed. So this brings into questions, is their land actually not covered by Treaty Number 9? You can see here, this is the AB line. So the AB line, that's from the Treaty Number 9 commissioners. That's from the Treaty Number 9 adhesions commissioners. This is the line that they're talking about. But in official text, it only goes, Treaty Number 9 only goes to the Albany River. So if this is what the treaty commissioners were saying that they're negotiating, if you go back to what's actually in the text that's actually in the treaty, then you can see that there's this line AB and all the area north of the Albany River. That can be thought of as unceded land. And here, you can see the AB line. So this is where it cuts off. And if you look at when they actually did the posts that they stopped up. So when the Treaty Number 9 commissioners were going out for signatures for the Treaty Number 9 land south of the Albany River, you can see that they went up the river systems and stopped at Hudson Bay posts, okay, to sign treaty. And as you can see here, Treaty Number 9, you can see all the posts that they basically visited. Up here, you can see the posts that they visited for the signatures of the First Nation people for the adhesions. And you can see Winis, the Severn River Basins, down here, the Albany River Basins, Moose River Basin. But here you can see, if you look at the line AB, so you can see that they never went up the Attawapiskat River Basin, Ekwan, Kapuskal. And so for this, you can see that there's an area here that wasn't visited for treaty. And this is why that the Attawapiskat First Nation people, they always say that they never entered into the treaty. So when the treaty was signed down here, the Indian agents at the time, Hudson Bay companies at the time, they were told that no one north of the Albany River was to participate. And so this is why Attawapiskat First Nation says that they never signed the treaty. The AB line, it wasn't something that we began looking at as, yeah, we should look at this, because John Long did, the Treaty 9 historian, John Long did mention the AB line, how this was a strange thing, right? But it was never, we never started looking at that, investigating the AB line for the AB line. What it was that we were interested in the northern border of Treaty Number 9 because we're looking at land underwater. And the reason why we're looking at land underwater is because land underwater wasn't included in Treaty Number 9. It was included in the adhesions to Treaty Number 9, but not to Treaty Number 9. And the reason why is because this whole coastline here, you can see that's in red. This is emergent land. So even though we talk about everyone, when you talk about climate change, they're talking about sea level rise, how sea level's rising up. That's not true in some areas, and that's not true in the subarctic of Canada. What's happening is the sea level's actually falling, right? The sea level's emerging. And if you talk to elders, if you've ever been on the James Bay coast and that, you'll see over the years, the sea level's not coming up, it's going down. And that's because of what's called post-glacial rebound. And what it is because there used to be glaciers all over the north. And when the glaciers melted, what happened is the land started to rebound up. And so as the land's rising, even with the sea level rising a bit, the land's rising more. And so that's why there's emergent land. So in summary, there were last minute negotiations because the government of Canada needed concurrence of Ontario. So this created a lot of things, and there's a lot of issues with Treaty Number 9 from a common law perspective, right? There's also things about what was actually agreed upon in the oral promises, but that's something different. The nature of the treaty process was very ad hoc. And so you have to remember at the time that the treaty was signed is that the northern regions of Canada weren't well surveyed. And this is why reserves, all the other things that were in the treaty, that's why it wasn't until later that surveyors came up and actually started to do the surveying for the reserves and that is because they really didn't know or really didn't have good maps of the north. So the commissioner's decision, so when they allowed the treaty, some of the Treaty Number 9 north of the Albany River into the treaty, right? They shouldn't have been because the Treaty Number 9 boundaries were fixed. And if you look at the two routes of the commissioners or the commissions as I showed earlier, you can see that the Attawapiskat River Basin, right? They really never went up there and had people sign the treaty. And this is because that when we're talking about the treaties and that, where they signed the treaties was all about convenience. It's all related to Hudson Bay Company posts. Those were where the treaties were actually signed. And they weren't built, they weren't based on any type of family territories or traditional territories, which would take into account the river basins. And this is why we have a question, is there still unceded land in Northern Ontario from a common law perspective? Lastly, I'd just like to thank Andrew Solomon, who spent many days, hours, weeks, years talking to us about the treaty, and the late Alex Stephen, who was a part of our research when we're looking at the emergent land. So, are there any questions?
Do you have any questions? Commerce.
Good morning. So how many communities are between that AV line and north of the Albany?
Oh, I really, c-
Today's communities, I mean.
I really couldn't answer that question, but as you can see where the AB line in the north of the Albany River, you can see that's where a lot of the mining activity is taking place. So I'd have to look at a map with the AB line,
Yep.
the Albany River, and all the First Nations that are north of that.
Another quick question is, so the adhesion only is the north of it, AB line
Well, you can
on the
see
text.
that's what, yes. So you can see in the commissioner's actual report, and you can see in their map, right? They have the AB line. And the other thing that you have to take into account is that DC Scott, the Campbell Scott, who took part as the treaty commissioner in Treaty Number 9, he became the highest ranking non-elected person in the Indian affairs, right? And so he had a part in writing up the second treaty, the adhesions part. And so if you take that into account and you take into account what the Kainai, what they're talking about with the AB line, it certainly seems that the AB line was the southern border of the adhesions, right? Although officially in text, it really doesn't give the boundary. It just says the northern part of the Treaty Number 9, right? So if you took the actual text of Treaty Number 9, that would be the Albany River. But as we know, that's not what the commission of Treaty Number 9 says. They said it was the AB line, right? And so you have to ask, what were the adhesion commissioners basically negotiating? And so when you look at all the diaries and all the correspondence in that, there's no other mention of the AB line. So this calls into question what was actually told to the First Nation people when they were negotiating. Does that answer your question?
Yeah, but I was just thinking, I know in the case of Admiralton, Fort Hope at the time, the event actually took place then in north of the Albany, which was then, as you say, I think Kuwaitan or Northwest Territories at the time, 1905. So,
Yeah, you're right. There's a lot of questions that come about with just the way that the Treaty Nine, Number 9 Commission, they went out there and just all the ad hoc nature, the way they just went about doing it. It's because they didn't know the enumeration, like knowing how many people, or they didn't know how many people were actually First Nation people were actually in the area to be signed by treaty, right? It was a guesstimate. They had no idea. And so this is one of the things, and they were only supposed to, like I said, they were only supposed to go up to the Albany River. And so it's a lot of the other people, if they weren't included in the treaty, then they wouldn't have come down and they would have just gone back inland because they would just been going to their other traditional hunting grounds. And so this is a question about uh, who actually signed the treaties and what were the actual boundaries. And so that's why with the AB line, there's a lot of questions about what were the actual boundaries and of the treaty and what was actually said to the people. Because as you can see with the treaty text that I showed you, that they talk about, like for Treaty Number 9, they talk about the northern boundary of Ontario at the time. And we know the northern boundary of Ontario at the time was the Albany River, right? And then for the other one with the adhesions, they just talk about the northern boundary, the southern boundary of the adhesions is the northern boundary of Treaty Number 9, which is the Albany River if we go specifically by the text. But as we know, with the commissioners for both Treaty Number 9 and the adhesions, there's a lot of discrepancy or concerns about what was actually told to people and what about this A-B line. So it's one of the things where, and that area is, like I said, the A-B line in north of the Albany River, that's where a lot of the mining prospecting's going on. So that's very important. Does that answer your question?
Mark?
Okay, good morning.
Can't see it.
I can't see who I'm talking to, but
Yeah, I'm trying to, yeah,
now, there you are.
can you see me? I can't see you though.
Yeah, I can see you now.
Okay.
Yeah, good morning. I'm from Niskandaga First Nation, formerly Lansdowne House. That's located on Attawabaska River. I think you know this presentation that you're talking about, we're in the same position as Attawabaska First Nation. You know, we weren't part of the signatory there. I don't think so. But supposedly we participated in 1905 signing in Fort Hope. And that's where, you know, our treaty comes from. But the adhesion, you know, we fall within the parameters of that north of Albany there. So, and I'm just asking that where does that, you know, we've always lived in Lansdowne House and we weren't part of the adhesion signatory. I don't know who signed on our behalf, but I don't think we will accept that, you know? So what
Yeah.
does that?
Yeah, so that's something where Attawapiskat, Attawapiskat First Nation, they've never acknowledged that they signed the treaty. And so it's one of the things where there's other First Nations groups such as yours that also say that. And so this is one of the things where what I presented today, this just deals with, these are just facts, right? These are facts. Court of law is different because court of law, the law is different than justice, right? And so that's one of the things where you as First Nations have to decide what do you want to do with the information that's presented, right? Some people, you know, in the past, it's been court cases. Other people, they just they want to get back to at the negotiation table, right? Just because, you know, when these so-called treaties were negotiated, um, First Nation people couldn't read, write, or speak English, so they didn't. It wasn't really a fair process. So it's up to I guess individual First Nations because they're the signatories of the, or supposed signatories of different treaties, and plus other regional political organizations such as NAN. They have to decide on, you know, what's the best way forward with these I'd say inconsistencies, but I would say issues with Treaty Number 9, because Treaty Number 9, I talked about the A-B line today, but there's a lot of other issues that are associated with it, and so that's something for leadership at both the NAN level and the First Nation level we'll have to discuss.
Lana?
Good morning. My name is Alana McKenzie and I work at Matawa and I'm a member of Muskrat Dam. But I am a fan of your work in reading your papers specific to Treaty 9. And I think that some of the work and the research that you've done is in the very detailed or specific areas of question that we need to be looking at in terms of the treaties, the 0506 and 1929-30. So, but what I wanted to ask you and also to share with the people in the room is about your paper, your co-authored paper, Treaty 9 and the question of unceded land south of the Albany River in subarctic Ontario. And just making people aware that what you had undertaken was the significant research to document or find proof of the lack of okay, so I'm just because I know that this is a complicated thing. It's that what it is that the treaty commissioners at the time of the signing of the treaty did not have all of the articles of treaty with them, that it was physically impossible from the time that the agreements were signed, potentially, that they didn't have all of that when they were meeting with our people to sign the treaty. So our people didn't have the full paperwork in front of them.
Yes, so you're talking about the agreement. So that's correct. So with the treaty number 9, there was an agreement, an associate agreement that was supposed to be attached with the document, but it was never attached to the document. And the other thing too is also the backdating of the different documents. And so that's another thing that would have to be looked at, and that would have to be in the court of law because that's something for common law, right? So it's like getting a person to sign an agreement and not having a portion of that agreement where the person could actually look at it and agree to it. And so that is the question, and that's something that that would have to be decided in the court of law.
Yes, and that's exactly why I wanted to raise your paper, and the question here is because our next section on the Treaty 9 law cases that we're having on our next session is that this is something that we could be potentially looking at for a legal opinion of what to do, because what that would potentially open is the 0506, the legality of the 0506. And I'm not a lawyer. I just am a policy analyst who's worked with reading all of these documents, as well as much of the Canadian government documents. And then coming upon Dr. Suji's work here, these are the very detailed search into pieces of information that is important for us in Treaty 9. So I just want to mark it so that we go forward, and that's so you know that it's kind of on the floor, your other paper too here.
Thank you very much. Yeah, it's my brothers are lawyers, my son's a lawyer, but it's these type of thing is they always tell me justice isn't law. And other people I know, they always say people can change the law to make it to suit them. So that's why getting a legal opinion is important. And and then it's, I guess, among yourselves, you have to decide what's the way forward. Because with the agreement in that, like what was written in the paper, it was, you see, the agreement was the reason why we were looking at the agreement too was because of the exclusion of water power areas from the reserves in Treaty Number 9. And so when we look, then we look back and it's like, well, the agreement, it wasn't attached and it was never part of it and just became part of it after the fact. And that's part of the things with all the you'll see with a lot of this Treaty Number 9 stuff is that it's revisioned what happened with later writings of the commissioners in that. And so this is an important thing because as you were talking about, you're a policy person, it's the legality of different process or legality of different documents. That's something where, yes, it is important to get a legal opinion because that's where it'll be decided.
And I think that the key point is that whether or not it becomes a legal strategy, but it's also part of the public information in the political strategy about the deception that was perpetrated on our people for what we have lost over time. So I just think it is really important that we also start including the other works that have been researched too.
Yes, I agree. And it's one of the things where the government oftentimes they just try to keep on stretching things out and hoping the issues will go away. But it's up to the First Nations themselves and political organizations like NAN to take it to, set their agenda, what First Nations want, what does NAN want, and then go from there and try to make things the best. So I have another meeting that I have to go to. So thank you very
I have
much.
a question before you go.
Sure.
The question I have is where we as a family do a traditional stuff. It was Treaty 9 area. Now it's there's a line there. It's Treaty 3. So I would like to see, seeing at this map in this book doesn't really tell me everything that I need to know. I need to see those maps where the 3D 9th line is, because in our area, it used to be 3D 9th. Now it's 3D 3. So if I go hunting on that line 3D 3, and I'm 3D 9th resident, I just wanted to know, I know that I can hunt anywhere, but I just wanted to know I don't cause any trouble to hunt on 3D3, because when our people go hunting 3D3, they go with our neighbors 3D3 area, and they go hunt on that area 3D3, and nothing happens. Same thing with 3D3, they come to our 3D 9th when they want to go hunt. So I'd like to see maps in order to understand what I'm looking at here. I know that maybe just only me that, everything is new to me. I know that I heard my dad being a chief a long time ago talking about Treaty 9th. And I was only 9 years old when he took me to his meetings. It wasn't like this, it was in the household. And now that I'm seeing the map over here, I'd like to see more detailed and more details. I guess I hope I'm not the only one that's having this problem. I know when we do something from the ground up, it's very important people to understand what we're looking at. Even the elders. That happened when I was asked to start traditional family law development in my home community. I had to do a lot of research fast Then I gathered the elders and I asked them, do you understand? Yeah, it frustrated me because they didn't understand what I was talking about. And also that I need to talk about our history, not a history, the ways of how we govern ourselves in terms of raising children. I was kind of frustrated when I talked to the elders because I had to go back to my teachings from my two parents. And in order to things to build it up. And I feel the same thing as this when we do a 3D. Like, it's almost coming from the bottom and up to this date. That's what I like to see here. But I want to come back when there's another meetings because this is important in our communities. I go to high schools and I go to the school in our area, in our community, grade 6 to grade 8. I ask them, do you know your inherent rights, your treaty rights? Those two, high school and elementary, don't even know what this is all about. And I'm sure it's like that in our communities. The only people that maybe have a little bit of knowledge is the leaders, politicians themselves. I think this needs to be taught openly because not everybody understands this. When I look at this map. Yeah, me, Gretch.
Thank you. So the traditional territories for hunting and trapping and that, oftentimes they're different than the trap lines that the Ontario Ministry has. And so this is one of the things where for the actual the ancestral trap lines and that, you would have to talk to the elders and actually map that out. And then it'll give you an indication. So like for the treaties didn't take into account at all the traditional territories that the Korean Ojibwe that in the Ojibwe used. They just did it from a common law perspective, from a very Western Eurocentric perspective. So for what you're asking in that's something where the individual First Nations and the and NAN would have to look at the what are called traditional trap lines as compared to what was instituted by the Ministry of Natural Resources. So thank you very much, and I just have to be going now.
Yeah, I just wanted to, I guess, answer the question that Harvey asked, what communities are impacted. So there was a study done in 2014. Like, this is not a new issue. It's always been there. A and B line, and also the potential Aboriginal title. There are three, not just one. There's one in Fort Severn North. There's a section there that's a triangle. And there's also the Hudson's Bay, James Bay water, the international water. So that's still unceded today. So the A and B line includes those communities, includes Slate Falls. They're in there. Niskandiga, Nibinamik, Webukwe, Adolfskat. There are 4 reserves that were set aside in 1905. At the time, there were Northwest Territories. That includes Mishkiogamine. Part of that is in the north of Albany. Part of it is south. Ebematuch is another one that was set aside in north of Albany. Martin Falls and Fort Albany Reserve. So those are the communities that are in the A and B line. So what's unique about the 4 reserves that were set aside in the 1905 is that at the time it was still Northwest Territories. So those reserve has special status there potentially could be still have Aboriginal title there, even though they're federal reserves. They're recognized as federal land at the time. So Dr. Sushi talked about anomalies. A and B line is just one of them. So there are several anomalies in Treaty 9. Treaty 9 is unique. So a lot of studies have been done. I think what tends to happen is that when we bring things forward, like issues like these kind, it's not it doesn't become a priority until someone like Dr. Shuji challenged it for what do you call it? It's called a peer review. So that's what we need to do in some of these studies we've done. So in 2014, Dr. Armstrong did the boundaries, not only just the treaty boundaries, it also included the provincial boundaries within Treaty 9. So it identified all the boundaries of Treaty 3, Treaty 9, Treaty 5, Quebec, and also the Hudson's Bay, James Bay. And what we found is that some of the communities are actually in Treaty 3. Some communities are actually in Treaty 5. Some communities that signed Treaty 5 are actually in Treaty 9. So a lot of studies have been done. So I have maps here regarding the 2014 study that even someone from the lady mentioned hunting boundaries. You can hunt anywhere as long as you prove that your ancestors have hunted beyond your treaty boundary. We have a case called Mikinak that says you can hunt anywhere that your ancestors has gone. So this individual is a Treaty 9 member. He shot a moose in Sulikout. So they went to court and he won. The court found that his ancestors went all the way to Winnipeg, Lake Winnipeg. So that means he has a right to hunt and fish in Manitoba, not just within your boundaries. Same thing with Matachewan. Matachewan is actually outside the Treaty 9, if you look at the map. So we always knew that. So a lot of the First Nations, Treaty 9 First Nations, or vice versa. There's what do you call it? We overlap. There was no such thing as boundaries until Canada or Dominion Canada start doing boundaries. So even Moose Cree, their hunting territory includes Quebec. Same thing with Waguchik. Majority of it is in Quebec. So those are the anomalies that the Dr. Sushi talked about. So there are a lot of them. So I think we bring these issues to the forum to discuss, possibly establish a process to address a lot of these issues. Because right now what's happening is we go to court. Yeah, court is fine, but the issue with court is there's a risk of narrow interpretation. Your rights become narrow until you're cornered. Although treaty rights can't be extinguished, the only thing that the government can do is that they can narrow your rights. So I think it's very important that we identify these issues, because there was a question. That's why this afternoon there's going to be questions regarding the boundaries and also the backdating of the treaty. So that's a significant issue as well. So not only backdating, they lost some of the schedules when they went back after treaty. So they had to make a new one, either make a new one. So those are significant issues that are raised in what the treaty commissioners did. So regarding the backdating, Canada, Ontario was still negotiating when commissioners left to Ozenberg. So what they did is they backdated some of the documents. So those are, again, anomalies that are in the treaty. So a lot of this stuff has been identified through research, but it's just a matter of bringing those issues forward to the community. So what do you want to do with these anomalies? So unfortunately, case law is there now. We know Bear Island. We know the Keewatin decision. A lot of the issues has been addressed potentially. For example, you don't need to sign treaty in order to adhere to treaty, rely on decision. If you accept a reserve, if you accept annuities, you adhere to treaty. So those are the obstacles we're going to face if we're going to claim Aboriginal title with the AB line and also the Fort Severn line. But with international waters, that's still unceded. Even Canada admitted to that in their internal legal opinion. So that's why that AB line came about was when Andrew Solomon was chief. Through his TOLE process, he refused to submit his TOLE because of the issue of A and B line and also the Aboriginal title on James Bay. So those are so he commissioned that study, the Dr. Sushi study. I think it's over 15 years now. So it's starting to surface now because people are starting to look at it because it's under peer review. So those are the things that we need to do. We need to have academics write a lot of this stuff. Dr. Long did his book. So those are the issues. So I have maps. So we can make that study available, that 2014 study. Thank you.
Okay, thank you very much. I'm gonna do somebody's glasses. So if you're missing, if you go like this and they're not on your face, that means you don't have them. They're here. Okay. So you can come and get them. Okay, so Amy, are you with us?
Yes, I'm here. Can you hear me?
Hello, Amy.
Yep. Can you hear me? Oh, yeah. Hi.
Okay, good morning. Yesterday, when you finished off your presentation, you had to leave something go off, I don't know what you call it, and give us an opportunity for the people to ask any questions on your presentation. So at this time, we're gonna open up the floor to if there's any questions that you have on the treaty, cases that are in the books right now, now's the time to ask Amy, okay? So Morris? Oh. Morris, what did I say? Oh, okay, but on the time to ask Amy any questions that you have from yesterday's presentation on different court cases that took place. She had to leave, she had other commitments. So now is the time to ask the questions. Okay. Okay, more. Oh, you need mic. Okay. So we're gonna. So Moore's gonna start. Who else wants to talk? Who's got a question? Harvey? Okay, so Harvey will be next. And Ron, and I don't know your name, but Cass 210 says. Okay, we'll start with those. Amy, so be prepared to answer the question.
Okay. My name is Morris Papus. I'm a member of Niskandaga First Nation. I live in Thunder Bay, off reserve. I'm not sure what the update is, but I did hear my First Nations name in one of the lawsuits there. And before I ask you a question, I just want to say that you know, these issues that you talked about, I mean, I just want to say that you know, this is why we get defeated, you know, because we sometimes First Nation is alone suing the government, you know, and they take that, you know, advantage, you know, because a single First Nation cannot do it alone. And I'm wondering, you know, I'm just wondering, you know, where our political organization is. I'm going to be talking about that later on in the open forum. But I don't know what the status is with this cool jurisdiction where my First Nation is involved. You know, you mentioned that it's, you know, that lawsuit is not going to succeed. And I'm just wondering, why is my First Nation pursuing that if they're not going to succeed? You know, I'm just, you know, I haven't gotten an update, you know, with respect to that because I live off reserve. Like, I mean, I want to hear your opinion, or maybe elaborate why you said that, you know, a little bit more.
Okay.
I could understand. Because
Okay. Okay. Thank you very much for the question and for the opportunity to clarify what I was saying yesterday. And I don't want to, I don't believe I said that it will not succeed. And I wouldn't say that it will, you know, definitely not succeed.
okay.
Apparently been amended to make it more clear that what they're looking for is shared jurisdiction. And as I, oh, can you hear me? If my internet connection might not be good. Sorry, just let me, so as I mentioned yesterday, on that basis, Ontario seems prepared to drop its motion to strike, which would be basically if the court struck the claim, then it would be the court saying this definitely will not succeed. And Ontario is not willing to take that risk if the claim is about shared jurisdiction, because it's not plain and obvious that it won't succeed. But what I was saying yesterday, which is my opinion, and different lawyers would have different opinions, but I guess the best way to explain it is that I agree very much with the comments that were made by Dr. Shuji just a short time ago, that it's important to know that justice is not the same thing as the law, and that when matters are going to the Canadian courts for decisions, the courts are part of the Crown system. They're an instrument of colonialism, and they're created by the Crown, and they have an interest in the whole legal system is basically has an interest in upholding the Crown's position. And so for that reason, anything related to governance or questioning the Crown's sovereignty, which is so foundational to what the Crown has done since the moment that it arrived, that the settlers arrived here in what is now Canada, as you all know better than anyone, the whole exercise from the Crown's perspective was about asserting a unilateral power to govern and to make decisions about lands and resources. That's what the Crown understands sovereignty to be. So to go to court and ask the Crown's courts to say that the sovereignty was shared, which is essentially what the co-jurisdiction case is, I wouldn't want to say that it will definitely not succeed, but there's a very big risk, in my opinion, that the courts will be too afraid to go there, because they're going to be they would know that that is going to create major upheaval in the Canadian, for Canada and for Ontario, and it would affect, probably the constitutional balance across the country. And so in that way, I think that understanding this risk, because of the fact that the courts can't really be trusted, in my view, to find something that is truly just. I think that just has to be borne in mind. I think the other big question for First Nations who are part of this case, and even those who might be impacted on it, is whether there's agreement among the First Nations that the jurisdiction was shared, because that's another big question. I think a lot of the First Nations that I work with and the leadership that I talk to want to have a power to manage lands and resources that is their own as well, and not necessarily shared with the Crown. That it's more of a nation to nation negotiation that happens rather than a joint decision making on everything. Whereas a shared jurisdiction, it sounds more like a joint decision making. So understanding that is another important piece in terms of the risks, and questions that are caused or raised by that case. Does that answer your question somewhat, or would it be helpful for me to elaborate a bit more on that?
Well, okay, it's satisfactory, but I just wanted to also, I know Ontario went to court on December 18th against the First Nations. Is that the same issue as?
Yes.
What was the outcome of that?
So that one, so in December, that was this hearing, which was a motion to strike. So what that is the co-jurisdiction claim was filed. So the claim was started, and then the defendants are Canada and Ontario. Ontario is one of and the defendants have an opportunity to bring something called a motion, which means that they go to the court, and at an early stage, they say the court has to decide something before this goes to trial. And what Ontario brought to court was a motion to strike, where they said, this claim is bound to fail. It's not going to succeed because Ontario clearly has jurisdiction to pass this legislation. So it's bound to fail. And that's what I understand from Kate Kempton, who's the lawyer leading this case, is that she clarified for Ontario and for the court that they're not seeking in the case, they're not saying that the First Nations have exclusive jurisdiction and that Ontario has no jurisdiction to pass these laws. Instead, they're saying that the jurisdiction is shared. And that's what's going to be, they're going to change the claim, or I think they've already changed the claim to make it clear that that's what they're seeking. So my understanding is that because they're going to make that clear that the claim is about a shared or co-jurisdiction, Ontario is saying that they're going to drop their motion to strike, which means that now the case will go forward to trial and go through the process of evidence gathering and go to a trial eventually, where the court will then determine after the trial if the claim succeeds or not, and if there's this shared jurisdiction or not. So, yeah, and I would say too, I should add further to your original question that I know, because Kate, I've spoken to Kate about the case a few times, and she has also, in some of her presentations to the assembly, to the NAN assemblies, acknowledged some of the challenges and the risks of going to the Canadian courts with this kind of a claim. And my understanding is that, part of what she says is that, first of all, she thinks it's going to take a long time to get to trial. But also, in the meantime, this is an important sort of leverage for the First Nations who are plaintiffs to be using when they want to challenge development in their territory. So, and a lot of lawyers, including me, will often say, it's good to have a litigation negotiation strategy where you're saying, you know, I'm going to go to court and fight you on this in court, or we can negotiate something that we can both live with. And there's some merit to having that kind of a strategy.
Yeah.
But the thing is, you have to make sure always in that kind of a strategy that the cases that are going to court are very strong and are going to, you know, win and advance the vision of the First Nations and what they want to achieve. Because otherwise, there's a risk that you go to court and then it narrows the rights, like Luke was saying, you know, and you don't want that, because then that weakens your negotiating position over time.
I'll stand up. Mike Morris, I'm originally from Christian, but I live and work in Casablanca Lake. I want to address what Adam said yesterday. This Treaty 9 document, my grandfather signed it on my behalf. So for me, this is the real treaty. And I've used it. I carry this with me along with my Bible wherever I go. I always carry Treaty 9 with me. I have some troubles with those court cases where our First Nations, like my friend here, takes to an Ontario court. You know, there is a treaty relationship that we're having problems with right now with Canada and Ontario. But we need to remember that there are 50 communities or First Nations in the Treaty 9 territory that need to maintain the treaty relationships between themselves. It's not good, I think, for that treaty relationship among ourselves to have one First Nation or 10 First Nations to take Treaty 9 to court without first informing us and asking if we can allow them to do that. My cousin, Chief Donnie Morris, is part of those 10 First Nations, but he never came to Casablanca to ask us, will you stand with us if we take Treaty 9 to court? Treaty 9 belongs to all of us in the Treaty 9 territory, all the people that we have. And our duty is to maintain that Treaty 9 for the 7 generations. It's a sacred document that we need to maintain. And that's where I really have a problem with, I'm just going to focus on that one, the 10 First Nations. Who exactly is taking Canada and Ontario to court here? What it says to me is the plaintiffs have the capacity of the ban within the meaning of the Indian Act. And our Aboriginal people with the Section 35 of the Constitution. That's not who I am. I don't belong to Canada. I belong to my own nation that signed Treaty 9, that my grandfather signed. He was part of that nation. I'm one of his descendants. I think I'm the second generation. And that's who I am. I'm not an Indian within the meaning of the Indian Act. Our First Nation is not a band within the meaning of the Indian Act. I'm talking about not the band, the Casablanca band. I'm talking about the people in 1929 that went from Casablanca to Agabon to Big Chort to be there July 4, 1929, so that they can see the treaty being signed the next day. That's the people I'm talking about. I'm not talking about being a band within the Indian Act. And that's my question, is it proper for First Nations that want to take Ontario to court and use Treaty 9 to call themselves bands within the meaning of the Indian Act and to be part of Canada as the Aboriginal people? I don't think it's right to take Treaty 9 to court along those lines. I think that's a very wrong thing to do. And I just wanted to have that, what are they doing here? I don't know the rest of the court cases. I only know about this one. And I don't know what it is that is being done here. I appreciate what they're doing because they want to stop the encroachment by Ontario and Canada to our traditional lands. And now they're asking for $95 million to, for the wrongs that have been done for the 100 years. I want to mention here that, for myself, like I say, I carry Treaty 9 with me wherever I go. In 2 years, well, 3 years, I hope I'm still around. It will be 100 years since my grandfather put his X on Treaty 9 and gave me a way, like it says in our declaration, that there's supposed to be joint management between our people and the white people on how we manage the land and resources. We haven't been able to get there. I don't know why. Maybe because we listen to the white man lawyers too much. That's the way I understand things, that we listen too much to our lawyers that are only trained to know what the Indian Act allows them to do, and that's what they give to us. And this one question I'm asking, what exactly are we doing here? If we're taking Treaty 9 to the court, asking for good things, but we're asking as bands within the meaning of the Indian Act. And we're asking as Aboriginal Canadians, I don't know what's being done here. Maybe you can shed some light on that. Thank you very much.
Thank you very much for the question. And there were several parts, and I'll try to touch on each one of them. But I think, first of all, on the issue about taking, First Nations or Indian Act bands taking Ontario and Canada to court, on the one hand, it's seen as proper in the eyes of the court that, that is how the cases on treaty usually are brought forward. There's been a lot of cases out, in the prairies and in BC Treaty 8 territory over the years, and usually they've been brought by one treaty nation, bringing it forward, and then the case, though, because it's about the treaty, ends up setting a precedent for everybody else. So that's one of the challenges about the process. But I think what you're also saying, I agree with. I feel like what part of what you're saying is that to some extent, this whole process, like I was saying earlier too, operating within this court process, it's the Crown's process, so bringing the case to court, to the Canadian courts, in the way that's recognized by the Canadian courts, is part of operating within that Crown-led framework. And it's not, it's not the First Nations framework that you're operating in when you're going through that process. So I think that is a concern, and part of why, in all the discussions we had last year, that I'm not sure if all of you were there, but I always say, I think it's very important for the First Nations to be, in addition to whatever's happening in court, to have their own vision for each of their nations and as a whole, and be working towards implementing that themselves without waiting for the governments or the courts to see it that way, because they might never see it that way. You know, they probably won't, because they have such a different worldview. And so I think it has to be part of a longer term vision for the First Nations to be working within their own frameworks, you know, over time, more and more, and kind of rejecting the Crown's frameworks. I think another question you had in there was about, you know, why are some of the First Nations doing this? And I think you touched on the answer too. And I think it's fair to say, in almost all of these cases, the annuities one is a bit different because it's more about the economic benefits in the treaty. But all the rest are, it seems to me, coming from a good place, or a shared understanding that's largely shared, that the First Nations never intended to give up their rights in their traditional territories to, you know, to harvest and hunt and trap and fish, but also to carry on their livelihoods and to govern themselves in those territories. And what we see now is this, you know, environmental destruction that is just accelerating, and the Crown has been taking up land since the time of treaty without any regard to that understanding. And I think that that's what I feel underlies the First Nations who are plaintiffs in these actions. They're all fighting against that in this way. But I think the other challenges, as you mentioned, about trusting lawyers too much and so on, when then the First Nation you know, engages a law firm or a lawyer to bring this case to court, the lawyer, they then, a lot of the time, they sort of run with it and they draft the claim and they develop the arguments, you know, and take certain positions that don't necessarily align with the positions that all the First Nations agree with, or even in some cases don't align with what they're trying to achieve. And that's why I think it's, when I've been talking about this over the course of the past year too, ideally, I think it would be Treaty 9 and Treaty 5 nations as a whole coming to their common understanding of what they're trying to achieve with the treaty, and then with their treaty relationship, and then instructing the lawyers to take certain positions that align with that, you know, and never, so that you don't have lawyers taking positions that cause unnecessary risks or that people aren't comfortable with. So I do think that is a concern, because in the end, the lawyers also, and I'm in this category too, you know, lawyers many of them are doing a job, you know, they can make money from these big cases. They can last for years. And so there needs to be caution always about how, you know, the instructions that they're getting and how they're bringing these important issues, which are very important, like the territories and governance are extremely important, but they need to be taking instruction from the First Nations and from the treaty nations as a whole, ideally, and not running with it in a way that causes unnecessary risk. So I hope that answers your question.
Ron, did you have a question?
Yeah. I'm Ron Wesley. I am from Kansas Lake. I'm just wondering, you know, when they're talking about this line, and I guys sit on a committee back home, and we've been doing a lot of research and everything into what we're doing in the land use. And one of the things that we found out is when the treaties were signed, was Fort Albany signed on behalf of Kansas Lake. So does that, and apparently they signed a lot of treaties within our area, and we were just one of them.
Mm-hmm.
And in Kansas Lake, we started off in Mamatawa, a place called Mamatawa, Then we moved to Paigo, then we became Kansas Lake. So we got this whole range of traditional territory that we reside in. And I'm just wondering, you know, when the signing of the treaties were signed, and there's always referendums when somebody always signs on behalf of you, and that referendum has to be 50+1. So is that legal document that Port Albany has signed on behalf of us? Because all our my dad used to say all our men were out trapping when that treaty was signed, and it was just women and children that were back in Mamatawa at the time. So is that what I'm saying? Is that treaty? Is that document real, or is that what they're going to follow, or not 50+1?
Yeah.
You know, and
Yeah.
I am just saying that because, you know, when I was a counselor back then with Arthur Moore was our chief, and they invited to Toronto, this group, they invited to Toronto to, and along with Port Albany, Saskatchewan, and Martin Falls. And they were talking about these dams on the Albany River at that time. And they wanted to build 4. But the thing about it is they already did their investigation before they invited us to the meeting. So that's a breach of you know, they breach and all these things without even telling us. So they were ready to build these dams. I mean, technically look into them. So these are just 2 questions that I had. So is that
Yeah.
You know, what can we do about it as a First Nation?
Yeah. Well, so thank you for the questions. And so the thing is, in terms of the question about the document, and you're saying, is it a real document, and talking about the signing, you know, the challenges with signing and understanding. And I joined a bit earlier and caught some of the discussion about the other anomalies in the making of the treaty. And there's so many, you know, in Treaty 9 and Treaty 5 and all of the historic treaties, really. The record shows that the commissioners were not, and especially in Treaty 9, it's a particularly clear record because of this Commissioner McMartin, but it's very clear that the terms were not being properly explained to First Nations who were there. The positive elements of protection and care and so on were being emphasized by the commissioners, and there was no understanding of a surrender or a ceding of huge amounts of land. And there was, you know, and often the language, always there was, you know, the language issues and translators that we don't know how effective those translators were, you know, and so but the issue is, again, going back to my point that I think is so important for First Nations to be aware of, about the justice is not the same thing as the law, and the courts are instruments of the Crown's framework, is that these issues have gone, like there was talk about an opinion, but and these issues have been grappled with by the Canadian courts, where the courts have looked at the discrepancies, the anomalies between the paper document and the history of the making of the treaty. Usually there was no real negotiation. There was never a ratification like you're describing. And, you know, and yet the courts have always done everything they can to uphold these historic documents. But the way they've done it is they've developed what we call a list of legal principles, which are basically rules for how the court has to interpret the treaties, which is very different from how you would interpret an international, you know, other sort of international treaties where everybody has legal advice, and how you would interpret a contract where you look at the words of the document. The courts have said, when you interpret historic treaties, because of all these anomalies, you have to look at what the commissioners promised, you know, what were the oral promises and the understanding of the First Nations, They'll look at the oral history evidence of what the First Nations understood. They've said the treaty has to be interpreted very generously in favor of the First Nations. So the way the courts have tried to get around these anomalies is to say, in order for this to be upheld, which they want to do, they will interpret them very generously to include modernized rights and to include, reflect the understanding of the First Nations to a greater extent than the document says. So that's where we see some of the courts, like Blueberry River, interpreting the treaty broadly to include the rights in all the traditional territory, or we see like the Restuel case, which was interpreting the treaty to include these higher annuity payments. And, even though it wasn't all spelled out in the document, but it was based on applying those principles. So that's my long-winded way of saying that there's a really, in my view, the courts will always do what they can to uphold these treaties because it's so important to the provinces and to Canada that they exist. And so it's more likely that they're going to try to interpret the treaty in this generous way than that they would say the document isn't real. And that's what we've seen, over the last few decades when there have been a lot of cases in other parts of the country. They've always tried to uphold it to the greatest extent possible. Just a minute, I'm just going to put myself on mute because I have a little cough. Sorry, and then the other question that you had was about the damming, and I think that relates to what I was just saying about how the province, especially the provinces and historic treaty areas, these treaties are very important to them. And when I worked for Canada for about 10 years, I don't mind sharing that behind the scenes, every time Canada tried to go outside and be more generous in terms of modernizing the historic treaty relationship, there would be, the provinces would threaten constitutional conferences, and, they didn't want it because what they want is the narrow version of the treaty where they say all that was set aside was the reserves and everything else that's covered by the treaty was surrendered to the Crown, and the province can then take up those lands for dams or for whatever other resource development they might wish to do. And they're very much still holding on to that, even if they don't say it out loud as much as they did. But we see that they still make those unilateral decisions. They're still prepared to do things like the priority projects legislation, which is in keeping with all of that, the notion that they can designate unilaterally and accelerate unilaterally. They're looking for willing partners right now, but they want to have that power to do it unilaterally too. So unfortunately, that's part of what underlies, I think, these actions like the damming and doing a lot of that unilaterally. It's part of that mindset of the Crown.
Harvey?
Thank you. Ben, my name is Harvey. Yes, no, I'm a member of Abmatung First Nation. Thank you for your summary yesterday. I'm not sure if that's part of the USB stuff that was distributed here this morning. And because I was trying to take notes as quickly as I can. I'm not going to comment any particular case here, except that I think an individual already mentioned that it's really unfortunate. I've been around since I think 1978, chiefs meetings and so on, talking about treaty, and at that time we pretty well, I think the consensus was that that we would not take the treaty to court because of the collective right that no one individual or First Nation can take that. So now we have half a dozen cases or more on the docket. So there's one there I like, but I'm not going to comment on it because the well, maybe I should, in order to ask the question. One thing we heard about the water diversions in Treaty 9, there's been several of them. And I know our people, because our trap lines extended to those areas, they were told, that we have to build these dams because you're contributing to the war effort. And because the boats are able to travel through the locks and so on. But when the war was over, the people said, "Okay, can you take the dam down now?" And I said, "Oh no, we have other uses. Besides, you don't need. What are you going to do with that water, anyways? It's that kind of thing." There was certainly no one that raised the issue, because at that time, I think the Indian agent was the sole communicator, I guess, with our people, and along with the clergy and Hudson Bay Company, because you can see on the record a lot of the letters that happened there. But the thing is, what I'm concerned about is that, like, we got all these cases going on. There has been some decisions made across the country, so whether it's a case in BC, whether it's good or bad, it affects us. And I think we know, like Dalgamuk, Mikisew, and others, even lower courts. And in Treaty 9 area, we have won cases prior to Canada Act, like the Chicho trapping case back in 1980, I think it was, where the court said that the provincial government has no right to regulate Indian trapping. And it was never appealed to the Ontario Supreme Superior Court, or Superior Court, a higher court, because I think Ontario didn't want to risk getting a decision against them. But the thing we didn't do is take advantage of that. So we have these winnings. Mashaki case has won the land use permit. There's other cases. There's small game hunting. We've won these things, and there's now 394 cases that we've won in lands and resources. And what we're not doing is commercializing or taking advantage of these things. And here we're going to another, to the courts, instead of asserting our treaty right and asserting that the courts. And the reason I say that is that these are the very institutions that we pound the table and condemn. Now we're running to them to make a decision, the wrong that the Crown, which, by the way, in our people's view, there was one Crown, not the divided Crown as it is today, Ontario and Canada. So anyways, I'm going off track here, but my question, I guess, there's a lot I could comment on. My question, I think you mentioned something about TLE reference in one of the cases yesterday. And I know with the other presentations, about, where they allocated the reserve land, basically 1 square mile for every 5. I guess the one question I have there is, has there been any challenge to that formula? Because that was, in our case, 1905, but it's 2026. Can a First Nation argue today with their current population that they would be able to increase their land, reserve lands? That's one question. The other one is to do with any of the cases. What is the process for being added as a plaintiff and also withdrawing? That's it.
Thank you. So for just your last question before you put down the microphone, do you mean being added as a plaintiff in any of these cases, or were you talking
so
about the annuities case?
If a First Nation is interested, I'll just the one I'm looking at is the water diversions. Manitoba, Ontario, Canada, recreation, agriculture, navigation, they all benefit year after year. But what they did is have a one-time settlement with the First Nations for that water diversion.
Yeah.
So today they're still making money, you know, and the day of what they call it, there's a minister of everything there, Greg Rickford, what's his title? Economic reconciliation. Well, anyway, I don't know what he has reconciled in his ministry, because he's certainly not talking to all the First Nations. He talks to select First Nations, you know, and so we're in the day of reconciliation, but it's not happening economically, I guess that's more of a comment. But so how do you withdraw from a case, but how do you add? How do you, what is the process for adding?
Right. Right. Okay, thank you. So I will again try, you have a few questions, or I know those are the two, but you touched on a few other things that I think are important to respond to also, and I'll try to touch on all of them. But on the first question about how to add or withdraw, how to be added as a co-plaintiff or withdraw, that's really a process of like working with the plaintiff First Nations, or depending on how many First Nations, whoever's the plaintiff First Nations, it would really be a matter of speaking to them about the interest. And then you would have, if you wanted to be added, and then you would have to have a retainer agreement with the lawyers who are running that case. I should mention actually on that water diversion one that I did receive a response actually late yesterday from the lawyers who are leading that case, and they said that they're amending the claim, and the claim will focus mostly on the water diversion, the historic water diversion, and not the Ring of Fire, Bill 5, C5 elements, which, as I thought, would likely be the case yesterday. So, and then to withdraw, it's the same thing. But then you would, if you're in the case, it means you have a lawyer, you've retained a lawyer, they're bringing the case on your First Nations behalf, and then to withdraw, you would have to basically tell the lawyer that you no longer wanted to be part of the case. And if you were the only plaintiff, that would end the case. You'd have to withdraw your claim. You know, and otherwise, if there were other plaintiffs, they could just move forward with the case. So then I also just wanted to, so you asked about the TLE process, that one. So most of the treaty land, I would say as a general matter, that we've not seen the formula changing. You know, it could always be argued, but the formula that was agreed at the time has generally stayed the same. But a lot of those cases, we often don't have full visibility into how they've been resolved, because they were resolved through the specific claims process. So, you know, for many decades, that most of these historic claims about the proper implementation of the treaty as the Crown kind of accepted it to be, which for sure the Crown Canada always acknowledged reserve lands were supposed to be part of that, and the proper amount was supposed to be set aside. But so those have generally been resolved through the specific claims process, sometimes in different ways as a matter of negotiation that is then confidential. So we don't necessarily know if there's, you know, how they've all been resolved. But usually the Crown will be trying to use the same formula. And the problem with trying to bring something new to the table now that was a big departure from that is that, again, this is the kind of thing the courts would be very nervous about, because they'll know that many things have already been settled through the specific claims process and the TLE process. So hopefully that addresses your question. I guess what I'm trying to say is that the arguments can always be made, but that's one that the formula that's been used up till now, it's likely that there'd be a strong preference for the court to support that. And then you talked about governance wins and then suggested that sometimes that hasn't been acted on. And you talked about you know, how Ontario didn't appeal. And I think it's an important point, and one I also want to say about the governance cases, some of the big ones like the co-jurisdiction and the Mining Act challenge and so on. And also the cumulative impacts cases have a governance element to them because the way of life included a right to manage the lands and resources. So anyway, the point is, you're touching on a very important point, which is that the governments, Canada and the provinces, are very nervous about going to the court on governance issues, especially when it comes to rights to manage lands and resources and traditional territories. They don't, when I talk about a good precedent and a bad precedent, the governments don't want the courts to throw a wrench into their view of how governance works. So they'll usually try to negotiate. You might have seen that, you know, right in 1995, when the first couple of cases started to come forward about self-government and governance rights of First Nations, Canada came out with the inherent right policy and said, we'll just negotiate this. Like, let's negotiate. You don't have to go to court. Let's talk about governance, because Canada didn't want to see the First Nations going to court because, of course, they would likely get confirmation of their governance authority. And then the question is just, how broad is it, and what subject matters does it cover, and how does it relate to Canada's and Ontario's jurisdiction? And they'd rather negotiate that. And I would say, I believe it is better negotiated on a nation-to-nation basis, you know, and that it ideally would be dealt with in the Constitution itself, you know, through negotiation rather than a court deciding, you know, the matter. But the point is, these cases that are going forward, they will make the governments very nervous. They are an opportunity to try to bring them to the table on governance and, you know, move forward on that. But then the issue is, like, if the governments aren't coming to the table and they look like they're prepared to go to trial, that's where this risk of whether the First Nations really want to go to trial should be based on how strong is the case and what are the chances of success. So, and then that, I guess I'll just mention that you talked about the watershed diversion case. It's a form of a cumulative impacts case. And the other cumulative impacts cases, you know, one thing I've always said about why I really think the Blueberry River precedent is an important one. And I see it as a big success for the First Nations, and hopefully it will be followed here in Ontario because of some of these cases. And that's because what they did there was they didn't challenge the system directly. They didn't challenge the surrender clause directly or the Constitution directly, but they said, clearly the treaty protected our harvesting rights, and this was connected to a whole way of life in our territories. And because they challenged it in that indirect way, in fact, what they got was a decision that essentially was an indirect challenge of the surrender clause and confirmed that the surrender didn't work, but they did it indirectly. And so I thought I think that's a very good strategy when dealing with the courts that I've said otherwise, you know, are kind of part of the Crown's framework. But that's a strategy that I think obviously worked in BC, and there's a good chance that it would work here in Ontario as well.
Okay, thank you. Doug?
Good morning. My name is Douglas Semple, and I'm not a Canadian. I belong to a group of Anishinaabe people up in northern Ontario. Yesterday's presentations were very, very informing and educational. One of the persons that made a presentation was Janet Armstrong. And I think in her overall overall presentation was, I think, was about the treaty in simple terms. And I wrote something as she was making that presentation. I said, treaty in simple terms. Here is another simple term related to it. Canada, they lied to us, and they are still lying to us. This truth affects our solution-making abilities in now and in going into the future. Like you talked about court cases and the thoughts of judges and the thoughts of Canada as they deal with us in that particular form. And my thing is that I don't think they'll ever deal with us honorably, because we come at them through that system based on our sovereignty, and they don't want to listen to that, because they've already made a decision to assimilate us into the Canadian statecraft, and they're not going to move from that. So that I think that basically is my simple position. I always try to take things to a basic level, and I think having done that, it gives me an ability to see clearly what Canada it tries to do to us. They think we are stupid, but we know what goes on. Our people that signed that treaty, Mesabe and all those other gentlemen that put their X's on the treaty document, Canada assumed that we didn't know what we didn't, just because we didn't know how to read. They thought we were stupid, I think, but we are not. We know what we want, and for the rest of the day, I think we're going to be providing statements of solutions, statement of truth to our leadership, to inform them on going forward with the process of dealing with the treaty relationships, or with the relationship with Canada in every aspect of it. We have a lawyer amongst our group that told us that to be careful if we move forward into the court systems. Siayang is what he told us, and because there's two treaties, he said. One is the written text, and the other one is our understanding the treaties as we understood them, which is never acknowledged by the courts, really, to any certain extent, as we would like for them to understand. And then, because we know that the courts are part of the Canadian statecraft, and their purpose is to uphold, as you said, the sovereignty of the Canadian statecraft, and that's a very that's what we are up against. But we still maintain our sovereignty over our lands, and I think there is ways to begin to deal with our issues based on that. Thank you.
Thank you very much for the comments and questions. And I agree, with your simple takeaway that the First Nations, the Crown, lied wasn't honest, certainly in the whole exercise of treaty making. And I think, and I missed Janet's presentation, but I've read a lot of her work and I have a lot of the histories across the country of the treaty making, and in every case, you know, there's a very clear record of the commissioners, as I said, focusing on positive elements, making all kinds of promises of a better future, and then, you know, afterwards, a real failure to honor those promises, you know, according to the treaties or otherwise. You know, and I think another thing that's important to share is that, you know, it's clear now also, you know, it's clear, and it always was to the First Nations, of course, but, you know, the Crown arrived, and at that time, the First Nations were here, sovereign nations, and using and occupying lands in their territories, and not needing the, you know, the permission of the Crown to do any of those things or share decision making with the Crown or any of those things. And the Crown has just from the beginning, you know, planted the flag and acted as if it had this unilateral power, and slowly but surely has always kind of worked according to that model. And I think we've seen some progress over the last while, but I do think that, you know, the way I felt about it, and I have to acknowledge, of course, too, that, you know, my background and ancestors came from those settler societies, and you know, but what I've come to see over time is that it's almost like being in a matrix. You know, maybe not all the individuals in it are bad people, and maybe sometimes the commissioners protested how the First Nations were treated afterwards when the promises weren't honored and so on, and but the system is designed to work in a certain way. And I think I fear that it's not very possible to change it from the inside. I think any kind of change that really is aligned with the First Nations vision is going to have to come from them, from outside that system, because the system is like the Titanic, like to try to move it or turn direction. I just fear that it's not possible. But and there was a lot of trust that was placed in the Crown by the First Nations, you know, at the time of the treaty making, and that trust was breached at every stage along the way. So it is a terrible history.
So, so it's Alana McKenzie. I just wanted to make, I know I have looked at the court cases that are currently underway. One of my main concerns with that is it's about the coordination of it, that they seem to be kind of chipping away at pockets, but yet there's some bigger activities or bigger legal challenges that we could be starting to develop. The first one from the earlier presentation this morning with Dr. Tsuji about their research that all of the articles of treaty or agreements were not with the treaty commissioners at the 05, 06 signings, and looking at how that may impact and potentially reopen that part of the treaty and whether or not that would then impact the adhesion. Like these, I believe that these things would potentially be together, and it's part of the keys that we need to find in challenging what the terms or outcomes of our treaty would be. It is important what was said, what we have heard Doug say and Harvey say, is that because there was deception involved, and that's what the Tsuji paper talks about, is the deception or the dishonorable actions of the Crown started even at the signing. And it's something that we continue with today with our current governments, whether it be Canada or Ontario, that they're still behaving dishonorably to the promises of the treaty. The second thing that I've been trying to get people to, lawyers and other people, to understand is that one of the legal challenges is for the Ontario Mining Act. And I believe that there's potentially a constitutional challenge there because the Ontario Mining Act deals with subsurface rights, and it completely avoids our Section 35 rights, which are on the top of the land. Because this law denies the recognition, protection, and implementation of our treaties, that it would be unconstitutional. Section 35 is part of the Constitution. Why it cannot be struck down on that basis is beyond me. And like I've said, and I've tried, and I always say, I'm not a lawyer, but I look at these things constantly specific to Treaty 9 and our understanding in the simplest way possible of the framework that we're in. So that's the other thing. As well as when we were talking about the anomalies, there is an anomaly also with the Pungassi and Little Grand Rapids, Manitoba First Nations. The Ontario government has recognized their traditional territory within the provincial boundaries. That to me is the precedent of traditional territory. How two Manitoba First Nations, and nothing against them, but how two Manitoba First Nations can have more rights than what is recognized by our own communities and First Nations in the far north is beyond me. Like, those are the kind of things that we need to grab hold to force the government to acknowledge, and when they're left off the table, that gives us nothing to work with. The other thing legally, like I would say too, is that we need lawyers to articulate the legal position that the Ontario government is using against us, that they are, and have it so that our leadership can have a reference to it, that it says, the Ontario government believes that the treaty was a land surrender, and that the kind of positions that they're coming against us with. It's all of the activity of the Canada and Ontario governments is based on the legal opinions that they have been given by their government lawyers as to how to push us around and minimize our rights and our outcomes. So on the flip side of that, like, we need that articulated for leadership so that we understand who we're dealing with and why they're responding in a certain way. So that was what I wanted to say about the legal cases and stuff.
Thank you, Linda. Amy?
Thank you. So I know, so I will just, so that again, there's a few points, important points that you've raised. And the first one, well, you raised it in regards to the discussion that was happening earlier about the AB line. But I think, underlying, as I understand your question, it's this issue about Aboriginal title versus treaty, the anomalies, and how to challenge some of those things. And I hope this will kind of get to answering your question, which is, I think, like, if you look at the situation, if the treaty was being negotiated today, and you see what happens when the treaty is negotiated today, because that's what's happening out in BC, has been happening for the past, couple of decades, and in the north and parts of Quebec, where the provinces didn't think they had a land cession treaty. And so what the governments thought was that they're dealing with rights and title, Aboriginal rights and title, which is based on what areas were exclusively or regularly used and occupied by the nation at the time of sovereignty. And when that treaty is entered into, what we see coming out today are these very robust, 400-page documents with a whole bunch of different rights and benefits and co-management of lands and resources and governance authorities. And, they're also not perfect, but they are a much more sort of honorable arrangement than what we see has been the arrangement for the historic treaty First Nations. And yet, if the historic treaties had been negotiated with this understanding that the Canadian court system has now about Aboriginal title, they should look the same, right? Like for it to be honorable, in my view, and I've always said this, it can't be, and it isn't honorable or fair for there to be nations who were among the first who were willing to trust the Crown and willing to work with the Crown and a part of the war effort and, all of those things. That the overall treaty relationship has been so much less generous than what we see coming out of BC and in the north. And that's based on the way that the Crown saw the rights at the time, but our understanding has evolved. And so it means that the historic treaties, at the very least, I guess my point is, I think that a question has to be made, a decision has to be made by Treaty 9 and Treaty 5 nations about what do they really want to see? Would they like to see, and then, you know, what is their position? Should they try to uphold the treaty, but take the position that these treaties need to be implemented in a much more honorable way and in a way that aligns with your vision for today? Or I think it could be argued that what was underlying these treaties was Aboriginal rights and title from the beginning, and what has been given in response has not been an honorable bargain, and so therefore those bargains shouldn't be upheld. That's kind of like the tension. And I think the decision has to be made, because from everything the conversations I've had over the years, I think many First Nations, and one of the first comments was about the treaty, and a lot of people, nations they want the treaty to be upheld, but implemented in an honorable way. So that's a tension, I think, and a decision that needs to be made. And ideally it would be made on a treaty-wide basis. And, then the Mining Act and the subsurface territories, I think the subsurface rights, in my view, a lot of the problem there is that same problem that we see a lot of these cases trying to get at, which is the failure of the province in Ontario, in our case, to recognize rights outside of the reserves. That Ontario's always been in denial about that. So far they're challenging all of these cases. And Blueberry River was really the first case in Canada, building on Mikisew Cree, which was a consultation case in 2005, but it was really the first case that confirmed that the rights in the territories continue. So the whole government system and the court system has been in denial about this issue, and the provinces, especially Ontario, are still in denial about that. And so that's why they think they can take up lands under the Mining Act and otherwise, as long as the area is covered by treaty and not a reserve. So, and that is just on the last point, you talked about a legal opinion or legal setting out the basis for some of this, and which certainly could be done, and to try to explain it in a clear way. But unfortunately, there's been many cases, back even 100 years or more. It was St. Catharines Milling and another big one called Seabold. And these were cases where actually Canada was usually trying to say, we need to implement the treaty according to what was promised. And then the province, Ontario, took Canada to court on that. And it went all the way up to England at that time. And the court in England said that it was the province that got the benefit of the lands and had to agree to the terms of the treaties in Ontario, where it affected the lands and the waters. And the province has operated on that basis ever since then. Those cases have never been overturned. So anyway, that's part of the background to the problem.
Yeah. Good morning again.
I do have to, I'm afraid I have to
I
drop
just have
off
a short
shortly.
question.
Yes, I'm happy to
yeah.
take another.
Within the federation, the way I understand it is that Canada's on top, and on the second layer is Ontario provinces. On the third level is where I am right now, Thunder Bay, and then they want me at the bottom. But I wanted to ask, who has, I know for myself, on the research that I've done since 1932, Canada's had the power to enter into any treaty that they want. And I just want a short yes or no. Within that federation, does Ontario have the power to enter treaties?
Mm-hmm.
Second question is, if they don't have the power to enter the treaties, why are we, the chiefs, allowing Ontario to continue breaching Treaty 9? Those are the yes or no, and whatever you want
Okay.
to do on the second question.
Yeah. So I would say the yes or no answer would be yes, that the provinces have the power to enter into treaty. And partly that's based on those old cases that I just mentioned, where what the court said was that under the Canadian Constitution, the provinces got the lands. So they got the lands and the resources unless they were subject to treaty rights. And so prior to that, Canada had entered into treaties on its own, including Treaty 3 was a good example, but that was the one that caused this issue or that went to the courts because Canada negotiated certain terms with the Treaty 3 nations. And then Ontario entered the Confederation and said, we don't like these terms. We disagree with these terms, and you didn't have a right to negotiate those terms. We have to agree with them. And that's what went up to these big cases back in late 1800s and early 1900s. And the court said, yes, the province has to agree. The province is the one that has the benefit of the lands. And so Canada still actually, would like to be able to negotiate treaties on its own, but it knows that if it tries to do that, the provinces will challenge. So like all the modern treaties, you'll see it's Canada and British Columbia that negotiate those, because if they agree on the terms, they know they won't take each other to court and fight about it. So there is some uncertainty, and always in constitutional law, arguments can be made because the Constitution can evolve. It's called, the courts say it's a living tree that can evolve as the nation evolves. So it can always change, but Canada and the provinces at this stage, they always do it together so that they're not taking each other to court about their jurisdiction to negotiate the treaties. So, and I know in the case of Treaty 9, for example, there was this agreement between Canada and Ontario that ultimately was reached about the terms, even though, so that was happening behind the scenes between them at that time, because this discussion and this dispute was already part of that relationship between them.
Okay, thank you very much, Amy.
Yeah. Yeah.
I know you said you have to be somewhere, so.
Yeah, I have to. I would like to stay for longer, but I have another meeting at noon, and it's freezing rain here, so I have to drive slowly. So I probably should head out now.
Okay, thank you very much.
But thank you. Thank you for all the questions and the opportunity to be here today.
This afternoon, we didn't break this morning. I mean, the questions just kept coming. But this afternoon, we're gonna have 1, 2, 3, 4 open forums. But I think the way that we're gonna do it is the way we're gonna have this afternoon, we're gonna have this afternoon, we're gonna have 4 open forums that in your agenda, there's questions that are laid out. So what we'll do is we'll probably have one here, one over there, one over there, one over there. The reason for that is that you're gonna have smaller groups, and you're gonna have everybody will have an opportunity to speak. So I think it's set up. I don't know how. Can somebody come and explain it, how it's going to be set up? So
Hi, everyone. We're going to have to shift again because our morning Q&A took a little bit longer. So we were thinking after we eat lunch, we'll do an open forum, just so everyone can talk. And then we can just continue the open discussion with some focus on the questions that we have, and we'll put them up on the board. Some are relating to the presentations from yesterday. And then that way everyone can kind of have their say. We have note takers here that will be listening and taking notes so that we can bring that back to our reporter to file a report after all this and get everyone's opinions and stuff.
Thank you. Thank you. Okay. Anyway, there's now 22 and we didn't have a break. So we're gonna break now and come back at 1 o'clock. And at 1 o'clock, we're gonna draw for a prize. At 1 o'clock, if everybody comes back at 1 o'clock, we're gonna have a draw. Okay, for your participation, called door prize or whatever it is. So that's what we'll do. So be back here at 1 o'clock to participate in that what you call draw. Okay? So, and you can go to the washroom, toilet, and everything at the same time, which you didn't have a chance to do. Okay, thank you. Okay. Wanna get ready to start the afternoon session? Still got a lot more work to do. If there's any people in the hallway, can they come in, please? So we're getting ready to start for the afternoon session. I promise you, I'm gonna have, what do you call it, draws here for your attendance. So, we're gonna do three. I'm saying we. All the people that are supposed to help me are gone. Celia Fisher. Celia Fisher. Nishi Dupuy. Nisha Dupuy. Not here? Okay, do it again. Lori Okamo.
Yep, okay, not here.
Not here? George Gakamic. George Gakamic. Okay. Wayne Slipperjack. Claude McKay. Gerald McCumber. That's the one we just did. Wayne Slipperjack. Angelina Kakamak. Glenda McChackey. Okay,
And then we'll do our pieces of the street.
okay, what we're gonna do this afternoon is, anybody that wants to, it's an open forum,
Yeah.
okay? We're gonna have an open forum. There's 2 mics over there,
Where?
and whoever wants to say, not anything. I was gonna say, anybody wants to say anything can say what they want, you know? So you have the list of questions here. Any one of those areas that you want to talk about, you can talk about. So it's going to open it up that way. So it'll be an open forum, and not going to be a workshop style. I thought it was going to be a workshop style, but it isn't. So I'm going to open up the meeting. Then whoever wants to start off the making a presentation can do so. Yeah. Worse.
Here goes it. Yeah, thank you. Okay, bonjour again. I hope everybody liked the chicken, but there's lots of leftovers there. Okay, he, hij tussen de man nog, hè. No, go got tussen tegen, I look at them as political issues. Okay, and I heard yesterday, Nago, that you know, are we dealing with these issues politically? Even our representations, like I mean, there's levels of representation, like you know, national level, regional level, territorial level, you know, and even at the First Nation level. He just going what I want to tell you is from the eye of the public, I guess. Like I mean, I have analyzed personally, like you know, from public view of these organizations that represent us. Supposedly, I guess they should be representing us politically. Well, examine or provide you more in detail what I'm talking about. I'm going to start off by talking about the Anishinaabe Nation. And this is my view, my personal view. And this is no offense to anybody. I mean, you can kick me out of their home if you don't like what I'm going to be saying. But I hear leadership, public, when they talk about Anishinaabe. You know, there's all questions, you know, what are they doing for us? You know, sure, you know, they come up with programs, money, and that's not politics. You know, that's just an administrative duty. Now, when you look back, when this was originally developed, you know, back in 1970s, you know, that I believe, you know, Rickard had a view and focus, you know, why he created this organization. Supposedly, my understanding is that, you know, to have a political voice and to strong, united within the 49 communities in NAN. When you look at the original name, Grand Council, Treaty Number 9. Now, I said earlier that treaty is a political issue, and that's the way it should have been. You know, because I see that the government always, you know, wins. You know, they dictate to us, and we accept those things because of money, funding, programs, you know. And that's what we're lacking here. Is you know, when I said earlier too that when a First Nation challenge the government about treaty, you know, they always end up losing anyway. In most cases, you know, as a First Nation, you know. But individually, it may be a slightly different, you know, that when we challenge government about treaty stuff, we should be united. Everybody should step forward and support each other. And that's why the government always takes advantage of us, as far as I'm concerned. And that's, you know, my view. Now I'm going to turn to tribal council. You know, originally when INAC back then in the late 80s, that they were in the process of downsizing. They called devolution process. And they wanted to form tribal councils. And before we accepted that as Nakina district chiefs, you know, we had meetings we talked about this. You know, and one of our late members, who was also a chief from Constance Lake, late Edgar Sutherland, had a philosophy, you know, how the organization should look like and how it should be run. You know, with two activities, you know, one politically and administration. You know, that's the way he envisioned how the tribal council should look like. And we started off okay. That's the way we started off. And over the years, again, the government took over. And that's the way Matawa is, in my view, today. You know, because we you know, I guess, you know, we accommodate what they want. And that's not the way this elder that I talked about wanted that. You know, that's something that, again, has been lost in the shuffle. But why is this happening to us all the time? You know, we have to question ourselves. And the other entity that I want to talk about is the Tikanagan Child Family Services. I was involved when Tikanagan was created back in, I believe, 1986. I was a chief then. And I felt that it was too good to be true. The way that Tikanagan was designed back then. Three of us, Webeke and Nibenamik and I, abstained from the vote, from the motion that was held by NAN. We didn't support Tikanagan at that time. And late Deputy Grand Chief Bill Nutting met with three of us to talk about, you know, to try and come on board with the rest of the chiefs then. It was designed to accommodate, to get away from Children's Aid Society, the way they operated. And again, you know, it was at the start, everything was in accordance to the way the chiefs wanted the organizations to run. But over time, as years went on, the provincial government took over. Eventually, today, it's back to square one, just about. I know what I'm talking about here because I experienced those things that I looked after children, you know, through Tikanagan process. And when these kids need something that they're supposed to be accommodated, I don't immediately get that request because it's a bureaucratic process that they've established. I ask for an item for the child that I'm looking after to a worker, and then the worker has to ask the supervisor, and that supervisor has to ask another level of supervisor. You know, that's the way it goes. And then before it gets to the finance office. Now they have their own mentality to the finance office, whether they should be issuing a check or not, or whatever. And I'm getting tired of that process. You know, I've tried to voice some of these concerns, but nevertheless, back to 1986 when Deputy Grand Chief, we were convinced, the three of us, because they had Webekwe and Nibenamik, those chiefs, they're gone. I mean, late Peter Jacob was Webekwe chief at that time, and late Sandy Yellowhead was Nibenamik. They both didn't agree, but eventually we did participate. We participated in principle. We said, if the organization doesn't run accordingly the way the chiefs wanted, then we'll get out. But those decisions were lost in the shuffle again. On my next term, I was not chief, so the next chief that was there, you know, fully supported, you know, Tikanagan Child Family Services. So I'm just saying that, you know, that every time we create something, sure enough, it's our way. But eventually it evolves back to square one. Why is that? You know, where is our political representation? You know, I'm not trying to criticize anybody by any means. You know, that's my view, and I think, you know, when I was invited here, you know, this is an opportune time to say something, you know, to try and get an attention and change our ways, you know, to be more strong as a united nation, you know, 49 communities from NAN, you know. The Snabiaski, to me, is not a political name, you know. Sorry to say that, but Grand Council Treaty 9, whoever didn't like that, you know, we should have stayed the way it was originally named. Then maybe our thinking would have been different. So I just want to start off by saying that. I mean, I'm sure there's other individuals here that will elaborate a little bit more on what I say. I mean, I take no offense if somebody wants to challenge that either. And I know that you may not fully agree with me, but I've been in this kind of environment, you know, for 44 years that I worked. And I think at least 10% of it is true. No, I mean, it's more than that. And I know that, you know, I wouldn't be saying this if I wasn't concerned, you know? So, we all have to, I mean, our leadership has to, step up, you know? Because, if I want to work as an administrator, I'll work as an administrator. But if I want to be a politician, you know, I'll work as a politician, you know, not an administrator, you know. So think about that. You guys.
You got more? Anybody else?
Bonjour. I want to say that I am in support of Morris Kagagitas, mainly because you told me that to stand with him and the Jimmy Gansis Gispinega we didn't do moment. I'm just joking. The like the one of the things that I think we think about is that how the state of Canada is built on not, and it's got a weak foundation. It's built on on money. Anything that's built on money is a weak foundation. And our elders from before us see that because their spirituality is built on their relationship with the Creator. So, having said that, all the minerals and all the things and all the resources under our feet and on the rivers of our lands, Canada wants that in order to continue its state to continue to stand. And if we can fully grasp that, what that means, we would find a way to create a strategy that would kind of destabilize Canada until they begin to talk to us seriously about our sovereignty and our way of life and our worldview as well. I remember when the province of Quebec had the showdown with the Crees over the natural resource of power from the rivers. Mi mitne again the Baccanon and the Crees until former Grand Chief Kunkam took a different strategy. He went to those people that were going to purchase that power, that hydropower, in I think it was in New York. He took his canoe and paddled there, carried his canoe on the shoulder of his shoulders and his people to that place. And he started the dialogue with this company And as a result, the company was able to decide that they were not going to purchase power from Quebec, and that put the province in a bind. And when they were in that bind, they decided to talk with the Crees, and as a result, today we have a Cree nation built on much of their principles and their thoughts and their worldview. Like not so much like it's not that I totally agree with the outcome of what is there. There is but something is there that empowered that nation to do what they needed to do to look after their people. I think the same kind of strategy we need to think about. Where is the resources under our feet? Who is wanting them besides the governments? Who's going to buy them? And these are the people that we need to engage in real discussions with them about the poverty that is in our nations, and is continued to be manufactured by the Ontario and Canada. That's what they are doing. Like they don't give us enough money to build enough houses. And there's maybe sometimes 2 or 3 families living in those houses, which creates poverty. And that's what we need, the message that we need to take to these very rich people who have no idea of what we live through. And we got to tell them that we want more than what we have now from Ontario and Canada, to be able to participate in an economy that should benefit us, because those are resources and minerals that they desire. And and in order to do this, we need a good governance system internally. Morse, the government gives us program and service in dollars with very stringent policies and so forth attached to them. That's how that's how they control us. So we need to look away from that and look at the situation and think about how we can change that. Like right now, the NAN is in kind of a bind because it requires those dollars and service and program dollars to function, and we need to change that. I'm not saying that we get rid of the programs and services. What I'm saying is that we separate that part out, have the executive director of NAN be responsible for that part of the organization, work with the tribal councils to talk with the government in maintaining those dollars, as well as maybe even enhancing them. So, and with the political side of it, and the Grand Chief part of it, that should be our responsibility. Maybe we get our people to donate. Maybe like there's probably a lot of our people maybe that have a paycheck or some form of income. If we can get them to pay an amount, I think we can talk to them and convince them that we need that for focused attention that the Grand Chief should should do in order to deal with the continued poverty that we are facing, and also to benefit from the resources and that our lands hold. We need the Grand Chief to be able to sit in boardrooms of these large organizations, these large companies that desire our resources, and tell them that our people are not very included in the benefits of these resources that we have, and we need to change that. So if we can, a lot of these guys, they don't see it, they don't have no clue, eh? But if we have a leadership that can tell them, that can show them, that can get it across them, I think they would change their mind to be able to help us or stand with us to change the mind of a very I don't know how to say it, but very bad government towards us. And I know that it can happen. We just need to change our governance structure to allow that. And it also would benefit our people that say that they give maybe $5 or $10 a month, that provides the budget for this new governance structure that I'm talking about. They would, I think they would feel empowered, because when they see their Grand Chief, I paid for that. I'm glad that I am able to be allowed to do that. For years, I've noticed, I've heard chiefs talk about direct voting by people to the office of Grand Chief. I don't think we necessarily have to do that, but just having people support our political institution through just giving $5 or $10 a month would change the way our people look at things. Miva, thank you very much for listening to me.
We hear Lucy Lampeter on the side. First, Lucy first. And then
Yes. Wajik, during lunch hour, my lady friends here at the table, we were discussing just what was presented this morning. And for me, I'm sure for many of us here, there are things that we learned today regarding the treaty, the AB line, and all the unceded territory. I mean, that's new to me too. But anyways, so we were discussing this, and then, we were saying too, like, our young people need to know this history of Treaty Number 9. They need to know this, and why isn't this information in the curriculum? And it says here, should NAN develop a treaty curriculum for use in schools? I think they should, because a lot of our young people don't know the history of Treaty 9. They don't know who they are. So I think NAN needs to step up and start working on on their education curriculums, get into the education, find somebody who's willing to do that, to work with the leadership. Because like you said, I say, our young people don't know where they come from. Can you imagine these little ones now that are growing up, the ones in public school, they won't know anything if their parents don't know anything. And us grandparents, we're going to be gone. Also, I wanted to say, I totally agree that with this gentleman here, what's his first name? Who?
Morris.
Oh, Morris Wapus. What he said. While he was talking, I Googled, why did Grand Council Treaty Number 3 change its name to Anishinaabe Husky Nation? And if you Google the same thing I did, you'll see all the reasons why they changed their name. And one of the things it says here is Grand Council Treaty Number 9 changed its name to Anishinaabe Husky Nation in 1981, formally solidified in 1983-84. To better reflect the political, social, and cultural sovereignty of its people, rather than just acting as a representative body for a specific treaty. Isn't a treaty more important too? So anyways, it goes on, and my understanding from, getting some information with talking to someone at the NAN office, one of the chiefs, they told me that, they told us, because I wasn't the only one in the room, that when they were, hang on. Okay, so they want to reorganize following financial and administrative challenges, including a deficit from the 1970 anti-Reed campaign. The group reorganized to better address the needs of its communities. So that was another thing. Grand Council Treaty Number 9 went bankrupt, or almost went bankrupt. So they had to reorganize, and they couldn't use Grand Council Treaty Number 9 again. So they had to change the name of the organization that's why they changed it to Anishinaabe Husky Nation. Good day.
Good day.
So that's what I wanted to say. Miigwech.
Okay. Good. Anybody else?
Good afternoon.
Can you state your name, please?
Colleen Archindijan-Kaz. I grew up in Wannaman Lake and became band member of Muskrat Dam First Nation in my early 20s. So when I first saw this gathering posted, I was very interested, very excited. I filled out a registration and thought I would bring my mother with me. She is a Wannaman Lake band member, and she received confirmation. I did not get a confirmation. However, I still wanted to be here. I wanted to be here. I look at it as like my mom going to residential school and me working towards meeting her. As second generation, I want to be able to see and understand what has been going on with our First Nations people. I am a language and cultural upholder. I do not put a job title to my name. I went to school and got my master's, and this is exactly what I looked at in my studies is the treaties, and it broke my heart. It really broke my heart. I saw so much devastation in our communities. I listened to everything that was said here in the meetings. Doug, Morris, from the bureaucratic level, political level, down to our resources. I'm gonna kind of like give you a little snapshot shot at the challenges of our everyday life as an Anishinaabe individual person. I I like hunting. Hunting is one thing that I see our First Nations, our youth, they need to be out on the land. That's our medicine. That's our healing. We are losing so many people, so many young people because of the teachings. Many have not been taught. There's a big gap between residential school and we see all these like the 60s scoop. We see Tikanagan, Delico all saying, this is my jurisdiction. They are all our children. They're all our children. And we need to pick up our teachings, bring them back out onto the land. Yeah, there's so many challenges out there. While growing up north, I see kids at the ridge with their guns. They're already practicing. I moved to Treaty 3. I'm out hunting with my husband. We get pulled over by the game wardens. And they told me to dump my bag, my medicines. We don't dump our medicines. We never should have to dump our medicines. And the game warden raised his voice at me, very authoritative. And I stood my ground and I stopped speaking English because English is a foreign language to me. I spoke my language. Our language is very powerful. We speak to each other to the heart when we speak our language. And so when I did that, he took my medicine bag and he dumped it. That's on him, not me. And they took my husband's gun and took my rifle. And he dropped my rifle. I look after all my hunting stuff. And there was a nick and the clip has never been able to work since then. And he threatened citation. I was not afraid because in the treaty, all I had with me is just my status card. And that's all you need to win in courts. But every day, our treaty is being chipped away at. Our health care is very poor. So we have individuals that are up to so many challenges. 2 years ago, my sister was diagnosed cancer and non-insured the travel. We had so many mix-ups and problems with the travel. She missed 3 treatments and she wasn't allowed escorts. And her meals were all buggered up. We lost her. She passed in 2023. January 3, my mom called me. Your dad's very sick. And this brought me back to a time when we were having a meeting with healthcare providers, telling their nurses, do not send anyone out unless they're absolutely dying. So my mom called me January 3 that evening, 8:30. Your dad is very sick. I said, call the nurses. Take him to I can't, he's real sick. I can't. Okay, tell them to come. By 11:30, they went to see my dad. And they said, yeah, he had too many pillows on his bed. And he has neck strain. And they used that Voltaren muscle rub that I had bought him that they saw on his night table for his wrists. I said, no. There's symptoms there. You need to take him to the clinic, do an EKG. Or we'll come back and check up on him in the morning. It was too late. My dad passed away that morning. So our healthcare, our education, our hunting, trap, everything is not being, it's breaking apart It's not holding water. These treaties are not holding water. All the treaties all across Canada. Ms. Webico. And so when we say we need to work in unity, that's a very powerful thing when we start working in unity, and making sure that there's thorough representation. So my message is to the young people out there, you don't need a boating license. You don't need firearms license. I don't have firearms license. I go hunting. I'm told you're only supposed to shoot so many feet from the highway. I hunt where I want to hunt. My message to young people, you go back out on the land. That's your treaty right. Practice your right to hunt, to live on your own land.
You good?
Yes, good afternoon. My friends on both sides of me. This is my elder from Casablanca and my old friend from Wabika. They say I talk too much, but treating was my life's work. I was 23 years old when my uncle Chris Comedy, he was the president for the west side of Grand Council Street, number 9. I was outside my dad's home chopping wood when he came to see me. I finished my high school that year. I was going to go back to, but the elders told me to stay home. So I stayed home. And Dad went to, Chris came to me when I was outside and said, I want you to work for Grand Council Street, number 9. I told him no. I was building houses at that time and I was happy building houses. 8 to 9 job and I'd go back to my family. But a week later, my aunt, Chris's wife, Annie Comedy, came to see me and told me the same thing. That she wanted me to work for Grand Council Street, number 9. I don't know about the rest of them, but when my wife tells me something, I do it right away. She's the boss, and I've always lived by that. So when my aunt told me to accept it, I worked for Grand Council Street, number 9 for 4 years. I watched Andrew Rickard deliver the Declaration of Slaviska. And one thing Chris said was, they were on this platform. Andrew was on the mic delivering the declaration. The chiefs, vice presidents were in the background. And one of the things that Andy did at that presentation to Premier Davis was he took a copy of our treaty number 9 and ripped it in half. Chris said later on, I was telling Andy, don't do that. That's my $4 you're ripping up. But anyway, that's where this declaration comes from, and I'm glad to see that it's included in the booklet. We need to take a look at that. Part of that is we need to renegotiate the treaty. That we need to renegotiate the treaty. I've had problems with that. Because some people tell me that Treaty 9 is sacred. So how can we renegotiate something that is sacred? But over the years, over the years, and especially since I heard this thing about the AB line, that Treaty 9 is not complete. You know, maybe it's time. Maybe it's time for us to take a real look at whether we negotiate Treaty 9 or not. We're smarter now. At least I like to hope so. We're smarter now, and we can do better than what's on there. And whether we do that is not up to us. It's up to our people. We need to educate them. And for the lady that was talking about curriculum, if you Google NAN, there is already a treaty curriculum somewhere in there. I know that because I printed out some pages many years ago. So there is a curriculum, but nobody's ever had the desire to spend the education dollars that we get to get it implemented. We don't do that at CAS. I do some presentations to grade 7, 8, and high school, and that's about all I do. And I want to bring out something. Let's take a step back. Take a step back when we talk about Treaty 9, JSP Treaty. Ask yourselves, who is it that can make treaties? If you do your research, there's one line that we sometimes use. Nations make treaties. Treaties do not make nations. So ask yourself, what is a nation? Who is that nation that signed the James Bay Treaty 9? In your area, who is that? In my own area, well, they left. Sasago, there's a leader that brought his people from Sasago and Berskin. My grandfather brought the people from Teakbush and Wannaman. Jacob Frog brought the people from Casablanca and Wagabone. Those leaders made sure the people were there July 4, 1929, so that they could sign that treaty the next day. I don't know what to call that group, but that's my family. That's the one that signed Treaty 9 on my behalf. Whoever those people were. I don't know about the rest of you, but for me, I have the treaty pay list, the first treaty pay list from July 5, 1929. I have a list of all the people that were there at Big Trout Lake. They got their $4 that day. The rest of the community should do that and bring that knowledge together. But I want to go back to nations. In order to be a nation, there are 4 requirements. One is peoples. When what's his name, Ron Lehman was talking yesterday, he talked about the difference between people and peoples. So we have to have our peoples. That S has to be there. The other one is defined territory. I don't know about the rest of you, but for us in that area where I come from, there was an elder. His name was Jimmy Tate. This is way back in the late 1800s and early 1900s. He traveled all over our territory, marked where the boundaries are going to be. He had a vision to do this. And me, I sometimes think that he was told to get our people ready for the James Bay Treaty 9. He marked all of our traditional territory. You have Sasago Lake, Berskin, Muskrat Dam, Kingfisher, Wannaman, Wagabone, Wabika, Big Trout Lake. All of our territory is marked. But the thing about that is, what he was given is that territory, that our traditional territory that he outlined, that would belong to us. The second layer would be shared. The third layer would be for the non-native people. And guess what? We're the ones stuck on the reserves. The Canadian government has managed to turn that vision around. That we live in poverty and all of the social ills that you know happen in your community. The other thing that they need is a language. Kwani kenda sinana izgishwe ginawa maskigok, Ojibways. But I understand Ojibwe a little bit. I understand Muskego a little bit. My father understood Muskego very bit because my grandmother came from northern Manitoba, York Factory area. So my father had to learn the Cree language, and he was very fluent. And the other one is a distinct way of life. What that young lady was talking about, to be able to live on the land that God gave to us. So if we have those 4 requirements, a people, a territory, a way of life, and a language, we have that right now in those 9 communities that I talk about that I belong to. Nobody else will tell you that. But that's where we belong, all of us, in those 9 communities. But the white man has come along, and guess what? We're divided into 9 separate bands, First Nations, which are further divided into 3 tribal councils. There's a lot of division, a lot of work that needs to be done, a lot of healing that needs to be done before we can even start talking about what to do with Treaty 9. We need to define who we are as a nation. And I would suggest to the rest of you, the Muskego, the Ojibways, and everybody else, you define who signed that treaty for you. And we'll come together at the next time. And I'm going to ask Bentley to work for us. That we call for a meeting again of the elders and knowledge keepers of Treaty 9 within a month's time. Give us time to understand this AB line case. First time I heard about it. But we start outlining how we're going to work with Treaty 9 when we come back. No lawyers to confuse us, just ourselves. We talk about who we are and why there's a treaty. We talk about those things, and then we talk about how we move forward, what we tell NAN to do for our people, and what we need to do from each of our communities. I say all this because I'm tired. I'm tired of having to speak at a church at the funeral of another youth that we lost to suicide or to drugs. I want us to do this work. We've let NAN and the lawyers try to lead us for the last 50 years. And we're losing more each day, like the young lady said. But all is not lost. The Bible says that God will give us strength for what we need to do. I believe in that very much. And my grandfather, Geordie Wennabitonga, put his X on the James Bay Treaty, Treaty 9. He was looking 7 generations ahead. I can't even look beyond one year. We're funded 1 year every year for our ban operations. That control has to be broken. You can't plan 7 generations down if you get funded for only 1 year. no chief, no council can ever do that. There are many times that I ask myself, why do I want to be on the council with all the change that Canada and Ontario put on me? And my answer to myself is, we need to break those chains. I am tired, and like I say, I'm losing our youth all the time. I don't know how many we've lost since the new year. But I want the work to be done. And I want that work to start, like I say, next month. For NAN to bring us together again. Not in this, I feel uncomfortable here at this hotel. It's too fancy for me, you know, because we're spending our people's money and our people don't have enough each day. And here I am sitting up there. You know, I don't know how much the room is, but I think it's way too much. We need to come back as far as we can down to our people's level. And one of them is where we meet, where we gather. You know, it's got to be something that our people can afford. I can never afford a room up here. And but I want to call for that meeting for next month for NAN to gather us again. More elders from the Muskegee side, and we have a couple of communities missing from our side. So we bring those elders together and we talk, just among ourselves, teach ourselves, talk, and plan ahead. No lawyers. I don't want to see no lawyers. Lawyers are confined by the Canada Act. That's all they can teach us. Our way is beyond the Canada Act that Canada has. Our way was here before Canada was born, and it's still here. Our job is to make sure it's there 7 generations down the road. Today I stand here as a father, grandfather, and a great-grandfather. There's 3 generations that are here for me. And I want to do a better job than what I've seen for the last 50 years from our people. May na wachigita na nanak magi mandu kaganan mo ko guys ba page go minamamo.
Very good, Mike. Anybody else? Saul?
Okay. My name is Saul Williams. I'm from Round Lake, Wiagama, North Caribou. That's the names of our community. It has 3 different names. I think it would be interesting for all communities to tell the story about treaty or tell the story about their community, how it came about. Like for us, we were discovered by accident. Before contact, we always told people not to come around. We told them stay away from our community, go away from here. And because we heard about sickness, we heard about all these things that came with different people. And that's why we were doing that. So in July 29, somewhere in that area, somewhere in that time in July, late July in 1929, we were gathered. There was families from North Caribou gathered in Nikip, that's on Windigo River. And we were there waiting for sturgeon to come ashore. And what people would do is club them to death. to gather food for the winter. Anyways, and when they were there, all of a sudden there was big noise in the sky, you know, and everybody got scared, and it was something that looked like a cross, because the previous year the preacher came and said Jesus is coming. He'll be riding on a cloud. So people got all scared and crying and running away into the bush, hiding. But the men stood by the shore waiting for that thing to land. They never saw a plane before. But why it landed there was it ran out of gas. They were flying from Big Trout Lake to Cat Lake, and they said they were treaty commissioners, and they said, "Who are you? Who are you people?" And our people said, "Children of the Crane, or the Jackonsak." That was our name at that time. That's how we were known, was the Jackonsak. And then they said, "We'll sign you to the Big Trout Lake Treaty." And our people said, "No, we want our own." And so in 1930, in July 1930, they came back and they signed us up to our own treaty, and they gave us a new name, North Caribou Lake First Nation. So we were no longer with Jackals. They gave us a different name. They even changed our names. The names they couldn't pronounce in our language, they changed it. Like in my family, we became Williams. That's why I have Williams' name. But before that, our name was Stand Around the Sun. Tedbagij Go Gabo. That was our name before that. And they couldn't say that, so they turned around and gave us a name. And I think that's wrong. And I think I'm trying to make an effort to get it back, but some people don't agree with me. And after that, we got a reserve, but we didn't like the reserve they gave us. It was a pile of rocks, nothing grew. And so we moved to Round Lake. And there again, our name changed. We became Round Lakers. No, that's the kind of story like that. I think people would be interested to hear about your community. What happened? What happened at that time? You know. Okay, thank you.
Bonjour, my name is Edna. I'm from Mishkigogman. I tried to ask this my coworker to say this when one of the people were presenting about the water. When Masabe signed the treaty number 9, Wegi Kito, as long as the sun shines, the grass grows and the river flows. When that lady was saying that there's no water protection. That's Misha we basic nipi kab mijung kagi kitut wete Mesabe. Miega ikitut 1905 to 1908 keep Mia at the Mesabe. Binish magagi nip miyot ugemakanak. Nimshomas to 1916 to 1925. Anim shimangi ya sinye pitch. That time, das 1969 to 1971. Sami congregation caso. Me mapigas machi non demand treaties. I was only about 8 years old at that time. He used to take me to the meetings. Echt in the march. Me yanyon gagi pawin the mogan yacht gagi sanik. Gagi kitoban. I witnessed all those things that I heard when he was a chief. And you know, get this done ration. You know, warfare. Shandoin. Mi mana go ye piga the beat second year shandoin. Kachigatek. Weshki kitobang gives and dogo chief and council were sitting around. There was no office at that time. It was at their houses. Tayatan yeah, it's gonna disrupt our way of life. This ration ashandoin gab mini going gau gamot zich kich kitoban. Dabash katagi kito in the magi kituk, they said. Me bogota boy yega yebak. Nobody didn't go out to the land to harvest. Panama in Panashamat nanum. Weski kitoban kaninga bay elgomot such camino kusina yeshan doin kitobanik. So I witnessed that in 1996. That's when the welfare system cut off. Then Ontario Works came in. Ni bush mabadon jijigan jo tap the gnyuk panaki kish kisegye a shandoin. A lot of children went into care that time. On that welfare system went gigishkinagatek. Chimena oni king this yenen getting snabelt the NAN. We but scanning economic ganin. I didn't go to residential school. My older siblings did. Not me, and I must have been almost like oldest of my younger siblings being out in the land. We but economic not hands-on. I learned early about the survival. Today, I still do that. I'm shago to go gaskiton na nagit san as a capita san. Me bago ye a pen with the land. I used the land to take my kids out there. Even my grandkids now. Batino guys are my grandkids. I take them to shore lunches, swimming. I stay in a deeper area to make them feel safe when they're swimming. Me, you know, medicines, me know, the she come and then I tell them what this medicine is about. My parents died at a young age, 74. To me, that's young. They died of breathing problems due to TB. Kanisha ngizin jogo akzim gung because of TB. I thought I was gonna end up like them. I kept going to clinic for oxygen. I couldn't breathe. So when I went in there and I asked my partner, let's go out to the land. I want to go get that medicine. What's your time get that medicine? So I went to go pick 2 medicines. I used them for my breathing. Because I used poppers. Me yet that day, as soon as I fixed that, I was lying in bed all the time. My feet became light. Then I got up and I said, hey, the air is so clean. So I never used poppers anymore. Misha Peach and get them our medicines. Our kids are dying. Our dad taught us about medicines. Na pop gi me na igona ki ba mi yang ani ge gong ga jna go ma mi chim gi jna ksno. Kinabago gang na pop gi min na igong. That food will go into our brains. That brain will regenerate itself. The human brain. Kikiting yeah. Counselors speak out and in it our community. How can the brain that's battling addiction can comprehend that communication between a counselor and a client? It's just opening the wounds, repeating themselves. The better solution for me, I think, is taking them out, feed them with our traditional foods and our traditional medicines. I'm not a politician, Ganin, but I believe where I come from it's strong. Don't you much go grab on any chance. I can say that I don't with the addictions. I don't deal with addictions in my own children today. And you get this opportunity zegas. Kanon the man panga kauni aocho kauni gitog ni chance snack. I'm familiar with that. I lost a child, Kenny. He got changing but it was so painful. I can understand why people use to cope. Maybe go moshi getting and shit uncle man now net the besan getting it them. Oh, you could go talk to somebody. 3 ladies came and talked to me. They all said the same thing. I was grieving for 1.5. After the last lady that came from up north, my grieving just went. I think that's the kind of counseling our people need to hear. Our own ways of counseling people. I was waiting for MNR they were at the band office. I'm going to talk to them. I said, I waited for them outside and I said, I'm going to build a cabin where I can have access to wild rice. And I see them outside walking out from the band office and I said, I'm going to build cabin there. I know I have the rights to build anywhere I want, but I'm going to do it. The reason why I said there's wild rice close by where we used to travel, and I want to bring young people to preserve wild rice, I told them. They couldn't do anything because I told them I'm going to go ahead. We have to know when we talk to those people where we stand. Where we stand with the system that's killing us already. That's killing our young people. The system, the provincial system, Gajgatek. I heard it on that presentation that Ontario has right to go into our traditional territories. So I got lots to learn about I don't know if this is called politics or treaties. Last night I was up. I went online. Going back to 1982, UN, when this UNDRIP for indigenous people. I went online last night to look at it. I did a little research. It's very interesting. I think our people need to know that our own young people back home, so they can tweet zot gewinot on the mad zot to go grab mad zot. I mean, yeah, so much you can to get me.
Very good. Okay,
Hello. I've never been this old before. It's actually the first year I turned this age. But the reason why I say that as we get older, I have become a mother, a grandmother, and in hopes that I will get to see my great grandchildren. And I'm a firm believer of traditional law. I went through the systems of child welfare system and also the residential school. And the reason why I say that, I believe that the Creator gives us a journey in life so that we can learn how we can move forward. You know, I've done the politics, I've done all the stuff that needed to be done in my journey. And there's a lot of times that I was angry at the way that we were treated. But then I realized that, you got to kind of shift the negative to a positive. So I think, Nini and the man, when we start to think about how I like this kaya kita chwete kichi ata we bach chigogo binosh chiga nanang I believe that we need our elders to create that foundation for the next generation. And then when you talk about the treaties, our young people, Kanita wants to say, no, I didn't really understand the treaty. I still don't understand the treaty. I still want to fight it. I still I want to be combative towards it. But when you kind of try to understand it, when that lady that was doing the history part, never all our history is oral. It's oral. And then the memories and the recollections, it's never somewhere we're gonna have to put and go say that we had a history before all the doctrine of discovery, all that stuff. We were here. And the systems that were in place were not chief and council. Those are the other things that we have to really look at, is the traditional laws of who and which families did what in each community. What your roles as a mother and an aunt or an uncle, okay, then those value systems that we had. So we need to really strengthen our communities, and what my colleague said too about going back to the land. As you were starting to do that, you see that shift in the communities. So Ninin and demand for the future in our language. We got to really get our languages because we're losing it really fast. So Ninin and demand. My foundation always been when I left for residential school, the first time that I was removed from my homeland, they actually came to our trap line during the summer. And my grandmother told me, she told me not to forget my language or else I will be lost. I thought I was going to get lost in a bush somewhere, but I didn't realize until later what it meant, that my language and my land were my grassroots. And I think the grassroots in the NAN have spoken that we want to do more. This, if you create, we're just talking, this colleague of mine, Edna, we do a lot of talking. A court system is not our system. It's a Western system. If you start to take something to court, they're going to dismantle it. We have to create a system, Geginit, that is going to be where it justifies who we are. And that's creating a more of grassroots home-based foundations for each community. Each community. Chimamusi Chigategen Dishnianon, that because this land right across Canada, Turtle Island, we are all connected because we were all here. So I think somewhere we're gonna have to, those things are still there, they're still intact. We just gotta refine them in the then. And I would really like to see that, you know, and more like Kedan Ashiminika Miyam Nan. I think it should have been had that foundation already. Because I was just talking to this other lady, Geninit, our group here. She said that in ceremonies, we need, it's what she said, 10 generations? It's already 10 generations. And here we're supposed to look at 7 generations. Me, I'm already into my 2nd generation, my granddaughter. So that kind of scares me. And then and then the traditional knowledge that they have, we know those are things that we need to talk about. Because they knew what we were going to be facing. Like, you know, that's what we were always told. My grandmother said that too. Who knew? Who, how, you know? Okay, that's all those teachings, the language and all are, that's where I started to understand. Always be careful. Is the other thing. So, you know, when we want to, and it has to be done. We're losing, like I said, like they said, we're losing our young people. We got to bring them back. We got to put that pride back into them where they're from. So those are my thoughts, Ninin, to kind of go with what's being talked about is I don't know if I'm a knowledge keeper yet, but I'm really hoping I'm getting there. But getting near me, guys, you know, my God, to always keep humor, be kind to each other, and in get ways you go to be mindful that your words don't hurt anybody. Because that's how we were giving people. And I think that but we were also given a greatest gift, and that's protect our children. That was the law that we had to keep to the Creator. So we need to do that. We need to remember those laws that we were given. So meaning and then the man when we talk about treaty, it's a Tagushi Nakunigin. They wrote it. But now we have to look at our laws, the Creator's laws, the land laws, all those stuff, our language, traditional laws, that's going to sustain our children. I try to practice that. I try not to lose my language. And I think that's the law that I have to keep is that language. And I have the system that's against me is that we're supposed to school our children. But in the schools, they don't speak the language. At a certain age from birth, even when you're pregnant and whatnot, you're supposed to be talking to that child you're carrying in the language that child is going to be born into. So we need to kind of look at language and education to really instill those values back to our communities. So that because when you're growing, I'm just going to throw that out because of language. When you're growing up to 3 years old, your body starts to mean. So if you're speaking a different language, your jaw structure starts to reform to that tongue that you're speaking. I asked my niece one time, how come it's so hard for you guys to speak Ojibwe? Because we have to shorten the tongue. And I said, why? And then I realized that because at an early age, kindergarten, they're already speaking English. But before, even at home, before we were even born, they spoke the language. So our tongues adapted to our jaws. So that's why we got to be mindful of growth education and all those stuff going. But I just wanted to say that because that has to be a part of the treaty because of the laws that are not written. So, Migach.
Not that I want to cut off the discussion, but maybe we need to take a break for 15 minutes and then we'll come back. There, if you look at the questions that were asked, some of these questions are you've been asked to write what you think and what should be done. So think about them. And we got a couple areas that we have to deal with. Okay, so we'll be back here at 2:45.
You want to? Yeah. Bentley.
She wants to now. She wants to speak next, and then you can use it. You okay with that? We'll make sure that the boss, yeah, that's good. Yeah. It's a big focus. Yeah? I don't know either. Actually, it's a new bakery with CITC. So when I deposit my checks, it was 5 days. And they never used to do that. Never used to do that. It's a new policy. It's a policy. And I argued and I said, take it off my account. After my checks, so me and I had a dealing with you. How long?
I changed my account, a couple weeks ago.
Yeah. Yeah, they do that. Yeah. That's what they do. So you have to tell them to take the hold off. Okay?
Yeah, we did all three at one.
Elders.
So why?
Oh, by the way, you have to be ready. Right here.
Why do we need driver's license?
Okay. This is good. This is all the time. All right, this is all. You only two have to find it, one, two. We have others here that. Okay. One is this. The other one is this.
Okay.
This is about the past specs. I give a plan, this is what this is. We call it. 47 is already. Like, if you leave the 13. Oh, there's no button outside. Was. And you can get that. Read the law and yeah. They all look at you. Voted up. Yes,
Keep that $4 to himself. And shoot. Yeah, you can find that. What do you call those?
Okay, can we get going again? Don't forget, I got 3 more, or 2 more draws to make, but you have to be here to win.
Yeah.
You have to be here to win the prize, the door prize.
They still. But it's but at the same time, we try to. I'm looking for another 25, 30 years.
I don't know. Yeah, I got you. I'm trying to give. Yes. Yes. Stand. Yeah. Okay, can we get started? Okay, this afternoon we have a couple of not that questions that are more important more than others. So, and I would like to deal with those questions. Not that I'm saying anything that's written on here is not important. They're all important. But I'm in when I'm looking at the clock and looking at what time people are gonna are gonna start leaving, and I don't want to miss anybody. But there is just a reminder that there's two I don't know what it's shopping bags or whatever that they're gonna draw at the end. Okay, so make sure everybody's here because you got to be here in order to win. All right, so when we have a couple of things that questions that were laid out for us and to discuss. And I know in terms of looking at the UNDRIP lady from over there said that there is she didn't really understand although she heard about it, but she didn't really understand what UNDRIP was all about until she came to this meeting, and where it was told to her what UNDRIP was all about. It's in the United Nations Declaration of Aboriginal People. So the question that's been asked is, should we not utilize the UNDRIP for to advance treaty issues or treaty rights? That's a question that's been asked there. The other question that's been asked is that should First Nation address treaty anomalies? I know it I can't really call it. I feel like throwing it away, but the anomalies, AB line, water rights, water beds, justice, provincial boundaries, Treaty 5, Robert's Land, and backdating the treaty. We could be here for another day just to talk about those things. So I'm going to seek your indulgence and hopefully that I can get some what you would like to see. The question that comes out from that is that should treaty be taken to court? And I'm not saying that we're going to do it. What I'm trying to get out of people is, what do people think? The other one is, what role should NAN take? As you heard, that some of the people, some speakers were not too much in favor of what do you call it, NAN taking on the lead role. But the thing is, we have to go forward. Don't forget that the Treaty 9 organization, or Grand Council Treaty 9, was put together by the chiefs and the elders. And there was a purpose for that. And that purpose was how we work together. Maybe we're a bit short on how the direction we take that, what we call it, how we work together. So it's something that has to be talked about for the future. And one of the things that it's been always talked about ever since I can remember, Treaty 9, was the sources of funding for court cases. The government's not going to give us money to take them to court. So we have to think about how we're going to advance that. How we're going to advance if we decide to take the treaty to court. How are we going to do that? There was discussion about a treaty commission. Talking about it here. We had a treaty commission. Grand Council had a treaty commission sanctioned by the chiefs. And we asked, what we did was we said that First Nations contribute to that commission. And there was a requirement that they put money towards that. And I think it was, if I recall, it was $15,000 per community. Anyway, we went ahead with that treaty commission. And I think there were 3 or 4 First Nations that put money towards that. Nobody else did. And that commission kind of died from there. And it couldn't operate anymore. But I think there was, Harvey, correct me if I'm wrong, 4 or 5 people that were identified to be part of the commission. And it was something that was very important because it came to the communities. I know it came to Constance Lake and talked to the people. So, should treaty nations pursue a form such as treaty commission? That's the one I'm talking about. Should we reestablish that, or should we try something else, or whatever? Should NAN develop a treaty curriculum for use in schools? And some people talked about that. I think this lady, one of the ladies, whatever, talked about it and said that it should be done. But as you know, we can't say to the government, we need money for treaty curriculum. They'll tell you no. Because of all the things that were brought out here. They don't want to know that. So those are things that, if you look at the afternoon part of our, what do you call it, agenda, and I'd like to open the floor up now for discussion on any one of those, what do you call it, points that are there. So if you can do that, do it in 3 minutes. Okay, 3
All
minutes.
Okay,
One of those points, do it in 3 minutes.
Okay, Boso.
We're all.
Gini na siya pinesin this ni Cas Priscilla Fisher due time. These ladies asked me to speak because we've been having round discussions here throughout yesterday, today, what we've been observing here and what we've been doing here. And but first of all, I would like to say to Miigwech to Nan for inviting me here. It's a great opportunity, and I'm very happy to be here because you don't get to be a knowledge keeper all the time. And why I say that is, I guess I'm starting to step into the next stage of my life as being an elder. I've never thought of myself as a elder. But I have lots of knowledge, wisdom. Like I say, I grew up from my background. I lived in the land. I lived with my grandparents, my ancestors in the land, my parents. I come from a big family. I don't know, maybe some of you guys know my father, Bruce Mendoegan, passed away early in his 70s. And yeah, we lived out in a bush. We lived there seasonal, you know, summer, winter, fall, spring. We were there. And I speak my language fluently. I'm only speaking so a lot of you guys will understand what I'm saying here. And when I go back to the history of the treaties here, I learned a lot of this from my own father, because he was a counselor, and his counselor members, because back then these counselors didn't have education, but they were there. And I followed them through their meetings, through their journeys. I was like their little secretary reading. I was really good with my reading, my education. And everything we talk about here, like the education and health, and, you know, I lived that life. You know, harvesting the medicines, that's all we used out in the land, bush. You have a toothache, you have a headache, you know, everything was there, and it's still there. Still today, I pick my medicines, I use my medicines, I use my language, I use my traditional knowledge, and I use my spiritual self. I started dancing. I, you name it. I know how to cook, clean, skin beavers, you know, and do all that, because I was, unfortunately, my parents taught me all that. Now going back to myself and having my own children, you know, it's hard. It's really, really hard to go back and teach your own children. Whereas we're mixed half and half. We're just talking about our status card, our driver's license, our health card, gun license. I just had to get my gun license 2 months ago. I'm waiting for it. You know, why are we still swimming in these streams? We're dictating with the white people. No, I have all those gun license, boat license, and all these things just to be out in my land. And the lady talked about, you know, them searching her. That's not right. Where is our rights? We talked about that. You know, there is a lot of issues here. There's a lot of stuff that, you know, I go back and forth. What I was taught still today. I try to teach my son that was singing here. And a lot of stuff I do still today. I go back to the land. I go back to the history. I go back to my ancestors. And when I talk about my ancestors, we go back 10 years, 10 generations. And I know because I go through my ceremonies. I do my ceremonies in the land, at home, in school, or wherever. I carry my lodge, I carry my pipe, and I carry the Medewan ceremonies I do for my people and for others. Not only my people, but for others. So there's a big issue about the waters. You know, I speak as a woman to protect our waters, not to tune in a bit. Panay, you know, I'm going to start using my language because a lot of you guys do understand your language and speak your language. Me wishem shkoan dagon come on no come gas musak. Wa can ge gon gaga to the mako de chik to mak ge gonen. Wa de gam jizio ziat we ki go mi gat yat panawa. Ya zibi ge out. Can ge gon no come gaga ant stewart. Me mes bosh gawa kwa. Wa nishna wa mi kna can ge gon gaga to the mako monaka. Mi mese bosh ka kuwa. Wa de kinen wa nishna ba ka ya wat ngitchene mak. Kun ge gon ka gi de wat wa kun ge gon ka do to mot. Ge ni mi ma ba se bsinta man. Mi ma se kinyo ma go an wa ndu tom data mission sak muk musak. Gitche muk mus. Wa te bsinta man. Wa ka besha. Bigya boyan geni noe gibe kinyo magzera noe gikitene dan yon geni kinyo magzun ya nok miki dan panangi kinyo magus gigunjge gibige ya tikent man ya geni ni ya tin video kwan mako kunwek wingen gisak tunia giab chitun Omodeske genini akine ktiya ya ne wangeni nona zebige nona kinyo moak benunti sen sektik gevina tikent mo to anisna we mikna gevina just tikka gigdo to me mase bukitian data ginnikia ugastu shunte kinyo magzien ugastu shunte dot manoa me asas meet moak we now to go singa gab good nico senior to do it man. Zin again zin again. Then Brian Miko Gia. Basic get dus basic creek yeah today penamania zin again. I now get that time to do it man. Me asan no come on to the asania. Anasnake oate need your kind mac can work. Anon oma can we can do tree, but the matter getting on can get pinji Ireland. Me messias to give she got that care 242. Me we gave ya she got boyat. Me eating getting pinji and a manaka can I miss some secret in Jayuk. Dus dus iten nutri kan genin ka besen te ya mi meten sin da ken makoa tinnis na bak akan ka we do kwen misshot ka we do quick shot where de kun ge gon nis na ba where de nutri kan o sa ma pana do bugdina o pana do nam o pogan ka ge Min go shan or the job to go to you go and get in or dip needs nishna by sick. Where the minge can da suk no sense. Minge can da so nonsense. Minge can da so monaka can get on. Yak can make or then it can you more. Me also a kid no actually got the kid to my key. Dum giwan genin matbe matbe besintaman genin yakin gigun ka do tamay ko wate genin tinikin mo go anasnan mission sakmuk musiko akin natu manoa o akasha musayat nugum ashesk me an want to minikawat skikisin und no trick mort Mies ever gossen maka gavin out buntige or tina no ya or to the needs nishna bike. Or this couldn't get on me on getting this the walk on dictin nishna bike couldn't get on. God sent more watch. They bought walk or they God sent more watch or couldn't get on me watch.
Yeah. Yeah, go ahead. Yeah, him and then.
Stan wanted to speak there.
I thought you were giving a mic.
He had his hand up a long time ago. Hey. One over there.
Yeah.
You want it? No? I'll just say a few words.
Oh, yeah.
They don't. Okay. Mingo, everybody. My name is Stanley Stephen. I'm a member of Constance Lake First Nation. The reason I came here to this meeting is because my chief told me to come here to represent Constance Lake. So today I feel obligated to say a few words on behalf of the Constance Lake and also for members of the Anishinaabe Nation. Anyways, I guess I am just like everybody else. I'm having a lot of problem with this dealing with this pamphlet we call Treaty Number 9. So to my mind, it's not written properly. It was written, but we were not included there. To me, it's a one-sided agreement. It was only the government agreement. We were not, we didn't really agree what's on there. I think they were forced. We were forced to sign it some way, but that's my thinking anyways. The reason I'm saying this is because, for instance, I can use an example. When they came to, they call it English River Post, which is Mamatawa. That's our original settlement. That's where we come from. There was a village there. And Hudson Bay Post. When they came there, according to the treaty that was written, when they came there, was not too many people living there, just a handful. And they told those people that were there, we're not going to sign a treatment with you people because you'll be part of a Fort Albany band. So I don't know, I guess there was no discussion. There was no discussion among the people that were there. It was only the commissioner that was doing the treaty. To my mind, for that reason, I don't think Constance Lake has the agreement with this treaty number 9. That's my thinking. Because we didn't sign it, our name is not on there. Because we were considered as a part of Fort Albany band. Another thing too, when you sign agreement, no matter what it is, there's supposed to be a two-party agreement, right? Like an example, if you purchase something, like a car or a house or a building, you always agreement. You have agreement in place. You have you and what do you call the one that's selling you a car. If you don't sign that agreement, then nothing happens. You won't give you that car. And this thing, I think this is what happened here. To my mind, this agreement is piece of garbage to my mind. I'm sorry to see you use that word, but there are some benefits here. We got some benefits from here, but not as much. But and the other thing too, we didn't know anything about that treaty number 9 till later on, maybe after 50 years after. In my mind, anyways, because many times where we were not allowed to hunt, we were not allowed to hunt moose, we're not allowed to hunt geese, ducks, we're not allowed to fish. If we get caught, MNL would threaten us. They say, you guys are not allowed to harvest any animals or fish on the land. And I believe that. I saw that happen. I'm the witness. And the other thing too is when you cut firewood, they'll threaten you. Don't cut that. Don't cut firewood. You know, and then when they tell you that, you're kind of scared. I got involved one time with those people. They told me, don't cut firewood, go home. So I went home. I had my sleigh with me, everything I need to get the wood out of the bush. I went home and I told my dad about it and my parents, and they were very mad. Why is that? Why were they won't allow you to cut wood? And I told them, I don't know. But they didn't mention about this. They didn't know anything about this agreement. I call agreement. It's very big. I think we should renegotiate whatever it may take it to the court and renegotiate that. I want and let the signatures here. All you bunch see is a bunch of X's. Whose signature is that? Anybody could put X. I could put X. Anybody could put that, but you don't know who is that. You know, there's no name. So, I remember. Do you remember when before the diamond? What do you call that? The beer diamond up in the Topscut? There was a developer came to our community. They asked us they wanted to build a road to Albany River to go to Athabasca to do their mining. So see what they did is they call all the elders, like the way the NAN is doing now. They call the elders to speak what they're thinking about this road they're going to build. So we went to the hall, the community hall, and the developer told us why they call us, because they want to build a road. They want our consensus, so to get that road going. And you won't believe what they did to us. All the elders are sitting around, and that guy there, he had a very thick $100 bills, all $100 bills. And he gave it to all the elders that were sitting around the table. And when somebody give you $100 bills, you don't question, why are you doing this? You're happy to get it. But for me, honestly, I didn't take that money. No way. I'm not going to sell my land. Simple as that. And these other people, they didn't understand what these people were up to. They thought they were just giving money. This guy was giving money to elders. And see, that kind of thing that was going on too. Every time the developers come in to our community, to our land, they always promise a lot of things. There'll be a lot of jobs, a lot of benefits, and all that stuff. But in reality, that never happened. They make promises, they don't keep their promises. And you ever see that? There's a lot of examples about this, these developments that are going to come into our community. Like, I'm not going to have to tell you this. There's a lot of developments. An example is a ring of fire. Everybody knows that. They talk about it. But we don't know what's going to happen. What benefits we're going to get the people that own that land? What benefit they're going to get? To my mind, I don't think they'll be working all right. Maybe after 10 years or 20 years, whatever it takes to extract all that mineral they're after, they'll be gone. They're not going to stay there. They're going to pack up their stuff and go. And for us, we're going to be here maybe in the next 1,000 years, generation to generation. And they're going to destroy the land. They're going to destroy the environment. You know, the environment is very important to us. We live on that. We use to survive. That's how we survive as a native people. We utilize all the nature that's on the land. We have medicine. We get medicine from there. We get everything. We water, whatever available. But these people don't understand. They don't understand how the native people live, how we survive. I met one guy in town in Hearst where I live, and he approached me, and he asked me, "Where you guys come from?" And I told him where I am from and all that. And he was kind of surprised. I told him. And she said, "Oh, I didn't know that. I thought you guys just fall down from heaven." And I told him, "No, we've been living in this land for 1,000 of years." And he said, "Well, I don't know. Nobody didn't tell me that." So that's why maybe we have to educate these people. We have to educate these people. And we have to educate our youth. In here, on the bottom of this booklet here, it says, should NAN develop a treaty curriculum for the youth in school? Yes, I agree on that. Because this is the only way that the kids or the young people are going to learn about this document that we're talking about that's giving us a hard time. You know, there's going to be maybe another 50 years before this thing become a decent paper. Like we go, it's going to be like a two-party agreement. Right now, what I'm doing at home, Constance Lake, is that the school always call me. They always call me. "Can you come over and talk to the kids? How the life was in the old days? How the native people live on the land?" And then I tell them, because I know how I live, because I was born on the land. So that's why they teach. That's why they call me, because I'm knowledgeable to the land. I know all the values on the land. And this is something that we have to do. We have to educate the young people about this treaty number 9 that's giving us a hard time. Maybe they're going to deal with it. Maybe not in our time, maybe another 30 years, 50 years from now. But I don't know. The world's going to last that long. The things that are going in this world, there's a lot of problems. And also the young people are not, a lot of young people, I know we have a lot of young people in my community So imagine that's happened to every community. It seems to me that the kids, the young people are not trying to learn these things. They stay home, watch TV all day. When you have meetings like a council meetings or anything at all, they don't come out. Not like we did when we were young. We used to go to the meetings and listen to the people talk. And that's why we learn. But today is different. There's too much technology. That's what's happening. And the drugs and alcohol and all that stuff. And that's one of the things I always tell the kids. All these things are out there now. It's not meant to be for us, for young people. It's destroying the young people. So we have to try to deal with that too somehow. I know it's a very powerful medicine, I guess. So we're just gonna do our best, I guess, but I think we get a lot of influence from outside, non-native people. Probably you're just laughing at us because we cannot handle our own affairs in our community. You're laughing at us. How you say that? A laughing stock. I think that's what they're doing. So someday, hopefully, the young people are going to open up their mind and say, okay, let's live this way. Let's listen to the people that are talking. Listen to elders because they know the life. They have long lives. They know how to survive and all that. Even though we have problems of our own, but we correct them as we go along. So anyways, that's all I want to say. Like I said, I feel I should talk because my chief sent me here. So it's my obligation and my duty to say a few words. Mingat. Mingat.
Mingat. Lauren told her, I don't know. Okay.
Next.
Yeah.
Okay.
Okay.
Thank you. We've heard a lot of good comments here in the last couple of days, and I think one of the things that I found, as far as my knowledge. Oh, by the way, my name is Harvey Yesno from Abmatung, and is the AB line to me. I've heard about it before, but in this term, I think that's one area. As far as the rest, I think I've heard those many times by different presenters on that. But one thing I'd maybe just remind everyone at the beginning, there is in our logo, we have that unity, strength, and success. And as much I try to aspire to do that, encourage people and so on, because it does work, but it's never been achieved. It's never been achieved at all. And it may never will be because we're thinking like the colonizer, and therefore we should decolonize our mind. All of our institutions that are urban based, so that's fulfilling the 1969 white paper to assimilate us into the mainstream of the society, and we lack infrastructure and institutions on our reserves. Yes, we have a paper exercise saying the head office of this institution is on reserve, but that's it. We're not creating the economy, I think, that was envisioned by our, the elders and chiefs, when they made that declaration. They were talking about self-sufficiency. And but each time when that happened, I think the government kind of came in and offered programs and services. So we kind of lived on that, becoming almost like the modern day Indian agent and, administering programs. We know now, and I haven't heard this, like for instance, with the updates we got on court cases, we didn't have many of the representatives here, or the plaintiffs here, but we got a third party to do a high level of that. So there's something wrong with that picture. If our Treaty 9 members are the plaintiffs on these cases, and we talked about it here, and but they're not present, yeah, there is something wrong with that. My collective right, treaty right, is being taken to court, and we may end up getting a bad decision. So I'm not a big fan of courts. I think I think that question there, should treaty be taken to court? My answer is no. I would do the reverse. In asserting our rights on the land, particularly on the land, let them take us to court for hunting and fishing and trapping and putting a camp in, cutting the tree, and so on. Let them take us to court. But to do it the other way around, I don't think. Anyways, so lawyers and consultants, and I find they hide behind privacy and privilege, and so they convince their plaintiff rep that you shouldn't discuss this case in front of, because you don't know who's all there. It could be government people, could be media, and so on and on. So we're now famous. Our organization is famous for having the in-camera sessions. In some way, it never fails. I've never, and I've been started working as a chief in 1978, and I don't ever recall having in-camera sessions. And those were very important issues. We kind of knew everybody that was in the room, elders and counselors and chiefs, those people that worked for us. We knew them. And so that's why in the last briefing, February 2025, I couldn't get into the NAN session in Toronto at the Chelsea because I wanted to hear the court cases. We said, oh, it's in camera. So I couldn't go in. And so I'm glad and thank Deputy Grand Chief Matetawaban and Andrew and the staff for having this forum, because I think that's what you need. And you're hearing from people that really care and talk and think about treaty and how it applies to them individually, their families, their land, resources, and the future. So what I'm going to say, as far as quickly trying to wrap up, I think we need a strategy, both in research, legal, financial, for this thing here, and I think in terms of how are we going to pay for this, Chief Wesley mentioned that the treaty is about economy. So I think on my own, I'm doing this now because I swore to my wife and children and grandchildren, I'm getting out of the politics. I'm going to get into the wealth creation. So I'm doing that, and I'm learning a lot there. For instance, I'm involved in the stock market, publicly traded companies, and so I've been beginning to know how that works. The big one today are, venture capital funds and AI. That's going to be the big one, and we're not even anywhere in there, And so I think we got something to offer to the world, and if we think that way, we are a nation. We think like a nation. So when you ask the question about should we be at international forum, well, if you think yourself as a nation, as it was declared in 1977, the Anishinaabe Nation, therefore, we go throughout the world. So, and declare our sovereignty. And but we're not doing that because we're getting bogged down with contracts with governments for funding and reports and stuff like this nowadays. So, but I think that's the thing. We got to create our own wealth. What we have in our lands, it's rich in resources. And if you want a hope in the future for our young people from killing themselves and getting in drug addictions and not caring about their own children and not caring about getting married and raising a family in a home, offer them a hope in the future where they have a job, they have a house, not sharing with anybody else, their own house, clean water, and so on. I think if you present that kind of vision to them, instead of government, you owe us money, give us more, whatever that is, that's never going to end. They only gives us subsidies. The other thing is what we need is, I'm glad a couple of people already mentioned language. If you want to instill pride to our young people, and teach them the values and traditions of our people, whatever that is. Talk about. You need to do it in their language. So no longer these kids will be intimidated in high schools, elementary schools, and college, university, because they're speaking their own language. And that pride in itself would catapult them to other things that you and I we haven't even been able to do. It's a shame that NAN has not settled the education jurisdiction. I think it's 25 years that's been going on. That means our kids would have been born and went to elementary school, high school, and got their PhD, and they're still monkeying around, making sure we got our honorarium on a monthly basis because we serve in a committee. In the meantime, we need educated people to do the stuff what we're talking about here. Can you imagine if we had our own lawyers here and researchers, our own people, instead of hiring people? That's what we need to. That's the building capacity. And as far as it's related to the economy, the other thing I want to say is that I've looked at other nations and talked to people that how they build their economies. Because if you go around in the Middle East and Africa and stuff like that, they had the same problem. The Germans and the English and the French and Portuguese and Spanish, they all went into these communities. They run their factories and institutions, their hospitals and universities. And in the meantime, the people were not, the local people were not getting involved. So what they did is they created a robust human resources strategy to create, not like our area management boards today that were created after Oka crisis in 1990 with Brian Mulroney. How many of those area management boards produced electricians, plumbers, with the red seal I'm talking about? How many of them are welders? Can they work in a pipeline? Can they work underwater to do welding in ships and stuff like that? None. Because it just was to appease us, keep our mouth shut, no more protesting from you and so on. So that's the thing we got to watch. We got to develop our human resource. And that calls for a strategy on its own. And so finally, what I want to say I think you and I as individuals too, we always look to an organization to do this and that. To a degree, yes. But if you have a mouth, if you have an education, if you have a ability to write a book, if you have an ability to be an actor, if you have the ability to be a writer or a speaker, a politician, and there alone, you have the responsibility to promote who you are in that position. So we can't look at one organization to promote all of this, especially if they're not interested, in doing that. And then I think that's the other thing we gotta. What's in us that the Creator gave us, and I think we have to use that. So I'm doing something there. I don't know where this is going to go. I'm involved with, it's called Indigenous Embassy Jerusalem. And again, what I was motivated for that, why I'm doing it, because I said at one time, we're a sovereign nation. There's God or Creator did not make a mistake with creating me or Ojibwe. He did not make a mistake. And he gave me some rights and responsibilities. you know, for all kinds of things. But I'm going to speak and tell people who I am, and you know, and so on. And I think that's where every one of us have that responsibility. So don't look to one organization to do this. You and I will be able to do that. And you see it in mainstream what happens. The Italians or Chinese and so on, they're academics, you know, they're philosophers and, you know, artists, you know. And that's what we got to do. We got to elevate those, our own people. You know, we got to have pride in them and say, look, here's an artist from, the, you know, Ireland or Webequer or wherever, you know, let's promote them. Just like that one artist that was part of the Olympics thing, you know, and that's the thing that brings pride, I think, in our people. So I'm trying to be as positive as I can be, but also give you some ideas. I think the key to me is strategy. I think, you know, that's why I'm saying the one thing I learned here is the AB line. All the rest of the stuff, because I've read all the treaties, you know, in Canada here, pre-Confederation as well. So I'm familiar with that. I'm familiar with the Canada Act, you know, and right now I'm looking to those 394 court cases I'm keep tracking on lands and resources, and we won those in our favor. And what we're not doing is executing those in our favor, either to commercialize or execute them and say, look, here's a court case. I can do this because that's my right, you know? So anyways, that's what I wanted to say a little bit here. Thank you.
You good, Harvey? Morris, you're next. Logan, you're next. I offer.
Thank you very much. Is that done?
No, but yeah.
Is it on? Yeah.
Okay.
Hello? Okay.
Yeah.
Now it's on now. I don't think I can say any more than what Harvey said. He took all my words that, no, I'll put it in my context here. But before I begin, Adam Fiddler walked by here, and I told him that it's not like in the days of Josiah's Fiddler. And I hope he knew what I meant by that. But anyways, I have to be excused here shortly. I have to go to the hospital, and there's a lot of knowledge here, and I think everybody that's here, I think there's a lot of things that I picked up, and I hope you have as well, you know, that what was said here. What I wanted to say is that there are questions up on the board that are being asked for us to answer. And I will say that I will not answer those questions because, you know, sounds like that the questions that I read sounds like that NAN is not doing its job. And they want us to direct them to, you know, is that what those questions are for? It's my question. You know, I think if I was the leader, you know, I would, you know, evaluate and review, you know, the context, the original version of those things that I know things have probably changed, you know, in the over time, you know, why some of the work is lacking today. I'm not saying that they're not working, but what I'm saying is that, you know, especially in politics, politically, you know, that's what I think is missing, you know, personally. So I think there were suggestions here that, you know, we form a group to analyze the situation and maybe form like an elders forum or something like that to to further have discussion on this issue that we've been talking about. Personally, I agree that there's something missing. You know, if I take treaty to the court, we heard that the treaty manual is a lie, and that's what the court is going to use, you know, to and what that means is that the government will defeat us. So we should first interpret our own version of treaty. You know, I tend to agree what the lawyer said about, you know, the treaty. What I heard from the elders that have passed on what the treaty was all about. And it's certainly that one sentence, you know, surrendering, you know, the land and whatever, you know, is not what I ever heard when I talked about the treaty with the elders in the past. So I think we should, you know, get more organized, you know, as an independent elders group, not involving the executive, because if they're part of that, they're going to influence, you know, the elders to redirect the words how they want to see fit. If I was involved in that, I wouldn't allow the executive to, you know, to talk to me how to put the treaty into context of how, you know, the other elders interpret the version. So I mean, that's something that should be considered. I know some of that knowledge has been expressed. Hopefully, the coordinator and as well as others who are involved will consider that to, you know, to get things on the move. I mean, this is your direction, you know, this forum that you hosted, you know, and you heard what should be expected. You know, never mind going back to Mike Matatawaban there. No, I mean, the executive shouldn't be part of that. I mean, they run the organization, but still, you know, I still think that this should be done if we're gonna get any headway with this treaty issue. And in terms of creating a curriculum, we can't use the document to translate that because it's a lie. We have to develop our own version, and somehow, once that's finished, once the version is finished, to try and have it recognized at some level. I know the government won't recognize that because it will contradict what they've already approved. That's a lie. This is something that can be ongoing discussion. I think we have to do this now in order for our future generation to, be successful in their, negotiations or whatever the case may be. So the questions, I personally think that nobody should answer those things because, if we do, and that's what NAN executive is going to use. Sounds like that if they're, it sounds like to me, that they want us to feed them direction, meaning that, they're not doing the real work that they're supposed to be doing. I mean, you can kick my rear end for saying that, but that's just how I interpret those questions that are on the board. So with that, again, I want to thank everybody. As soon as I get off the microphone here, I'm going to leave. So hopefully that I see everybody again at some point, and I'm going to continue to analyze these situations myself. And you'll hear whatever, whatever I find at some point, because sometimes the mandate is not being honored, by these institutions that we create, So I want to now, I want to acknowledge the drum that was played this morning. Bentley, for your good job being an MC, and Andrew here for his coordination of getting this a very important conference going. And I can certainly say a lot more about what I learned from the past elders that are not living anymore. So the presenters, I thank you very much. The staff and the lawyer there, Adam, and all the speakers, and my buddy Arthur there. Thank you very much, and Ron. So with that, you guys get the number. Thank you.
Be good job, Morris. Logan Jeffers.
Judge, good afternoon. Lawrence Jeffers Nishigasan. My nickname is Logan. Most people call me Logan. Most Cree First Nation Duchin, Netiwinnebigo. I first heard about the treaty when I was about a young boy from my dad. Yeah, I'm the great grandson of a treaty signatory, John Jeffries. That's my great grandfather. So I have a bit of a personal connection to the treaty. It's always been in my heart since I found out about it and heard about it. And I teach it. I don't teach the treaty, I teach the treaty making process. How the treaty making process was done. That's what I teach. And the elder that spoke, I understand what he said. You can't teach it because it's not really the truth. I talk about the process, and I teach at the elementary school level, and there's non-First Nation students there. And they're very surprised when they hear about it. And what I do is I hand out papers, a document like this, 3 or 4 page document, put it all face down on their desks. These are grade 6, grade 5, 6 level. I put it face down. I tell them, okay, turn your page, but the document is written in Cree syllabics. They said, I can't read this. That's exactly what my great grandfather said in 1905 when he read the treaty. He couldn't read it. It was a corporate document presented to him in English. He couldn't read or write English language. He didn't understand the English language. Why was it not translated for him? Reverend James Evans developed the Cree syllabics in James Bay in 1849. Bishop John Horton translated the Bible into the L dialect, Cree syllabics in 1850 or 1851. There was 55 years of existence of the Cree syllabics in the James Bay area that are not used by the federal government. Why were they not used to translate the document to the Cree syllabics? We all know why. They just wanted to shove it through and it gets signed. So when I got invited to the, I went to, I've been involved with Treaty 9 or NAN since 1980s, I guess. Whenever I was a band counselor, I would ask my chief, I know you're a busy man there, chief. Can I go on your as a proxy to a National Ski Nation meeting? Yeah, sure. So they're very busy people. So I always ask them. So I came to a lot of meetings. I met a lot of chiefs, a lot of elders, and I listened to all of them. And I am today because of the elders' teachings that I picked up along the way. Not only from my community, from Northwestern Ontario, all over NAN territory. And that's what makes us who we are. We take advice from the elders. I always tell this story or joke when I teach the treaty process, treaty making process. I say, there was only one time in our history where we didn't listen to the elders. That was in August 20th, 1905. When the treaty was signed, the commissioner said, let's have a feast. And the leader said, let's have a feast. The elders told him, no, don't feed them. They might never leave. And we've been paying for that mistake ever since. That's supposed to be a joke. You're supposed to laugh. So I tell that every time I teach a treaty, because the importance of listening to our elders. I think if we're going to teach the treaty or the treaty making process, I think we need to start at the grassroots level, right here. This is grassroots level right here we speak. Okay, our grassroots people know each other better than their leadership. We get along better, we work well together, grassroots level. It's our leaders that are always discussing or in disagreement with each other. I say that in front of my leaders back home. I don't know if I offend them or not, I don't care, it's just the truth. And that's where this has to start, and I commend Luke Hunter, this department, Andrew, for bringing this to this forum here. This is where it has to start. As we speak right now, there's 7 chiefs sitting with Prince Charles in England, having a meeting. They're from the Treaty 6 area. That's one way of doing it, but I would think it would start right down here, at grassroots level. Because One of the things we have in our weaknesses, we don't have any documents behind it with us besides the treaty. When I was sitting across from the gold mine company that wants to do work in our area, I had nothing to back me up. Nothing. I couldn't speak of any laws or say anything written. So what I did was we had 5 environmental issues we were arguing about, couldn't agree to it. I took it back to my chief and council. I got a band council resolution making a decision on those 5 items. Boy, they were mad. You didn't have to do that. Yes, I did. You guys didn't want to listen to me. So without realizing it, I may have developed a constitution, the beginnings of a constitution, which is what I'm going to bring up next. Right now, every First Nation in NAN, probably other treaty areas too, when industry knocks on our door, we're scrambling around in an ad hoc fashion. Put a committee together, have a referendum, we're scrambling around. If we had a constitution, we wouldn't be doing that. How is it related to the treaty? The treaty would become a covenant in that constitution. And it will help us. So instead of running around developing laws as we go along, we should develop one now. A NAN-wide constitution, which will also have individual First Nation constitutions. So when some industry knocks on our door, here's what we say. This is where Moose Cree says. This is what Nishnawbe Nation says on this issue. You cannot change it. You can't argue with it because the people said it. The grassroots people made that decision, not our leaders. Our leaders, our voices were the grassroots people. So when we talk about treaty, and I think about when we say, do we take the treaty to court? I would have to disagree with that. Why? About 40 to 50 years ago, I'm just giving away my age now, the elders in our area stated that do not tarnish the treaty. Do not do anything to hurt it. It's a living document. It's the only connection we have with the federal government. So do not tarnish it. And if we do, if we succeed in taking it to court, will the government, the courts have an umbrella decision that affects all 49 First Nations. That's the thing you've got to watch out for. Instead of just dealing with the 10, is it about 10 people that First Nations that are doing it? Instead of just dealing with the 10, they might deal as a whole thing. So when I don't think it should even get to probably at the courts now, but I totally disagree with that because our elders have stated that. And I always believe that. It is the only thing we have going for us right now. You might look at enhancing the treaty, but never open it again. Don't ever open it because you don't know what you're going to get after that. You might get less than what you started with. So if you enhance it, I think there was an attempt to enhance the treaty back in the 90s, but the AFN couldn't agree with it. They shot it down. I was working as a lawyer, Stan was a lawyer, Chatting was a lawyer at the time, working on that. And I think I don't know what happened, but they probably couldn't agree again, like I just finished saying. So I think we need to start at the grassroots level. We're talking about a treaty. And we need to do a curriculum. Yes. I have a USB that I work with. That was developed for me by my friend, Dr. John Long. He showed me how to explain the treaty making process. And when you think of it, you can't think that this country became a country without that treaty making process. That's where it all started. That's where Canada became a country. It's where it all started. The federal government signed a treaty with the First Nations people of Canada for the sole purpose of legalizing their activities in Canada, period. That's all. They didn't give a hoot about our treaty rights, fishing rights, and all that. That's all it wanted, to protect themselves. So when you talk about the treaty, I think we need more meetings like this at the grassroots level. And again, I thank Luke, good to know that Luke's department's working on reviving it or bringing out discussions about the treaty. I'm here because my current job, my boss said if there's anything to do with treaty, you can go. My current position is a lead for the residential school initiative. And he said if there's a gathering and treaty, you can go, but make sure they foot the bill. So that's my directions. The reason I wanted to bring that out is when our agreement was developed, our proposal, it included the East Coast people of James Bay, the West Coast people of James Bay, Northeastern Ontario. The missing component is Western Ontario. It's missing in our agreement, and we know it because we saw Horton Hall students growing up in Moose Factory. Some of them became friends with us. And we're working on that right now. We're trying to contact people from Northwestern Ontario to work with them. We're trying to make them part of our contract, or part of our proposal. Right now, we invited, last 2 years, we invited speakers from Fort Hope and another First Nation, because we're very sticky about how we spend our money. Government says you got to spend it on Moose Creek First Nation members. So we get a little creative. We invite them as guest speakers. So as we speak, my staff are probably inviting people from Northwestern Ontario to come and speak at our meeting on the end of this month, March, come to our regular meeting. We want to establish a connection there, because I know a lot of Horton Hall students came from that area. We have a representative from the East Coast. We have a representative from the West Coast. What we need is a representative from the Northwestern Ontario to sit down with us, because a lot of you went to Horton Hall. And I'm trying to give this young lady my business card. If you can give it to somebody she knows in that area, or somebody that wants to come and talk to me, I can give you my business card. And it's all connected to the treaty, how we work together. And I think what is the here I wanted to comment on? Oh yeah, the creation of a treaty commission. I think we started that back in 2009, is it? Or 10, around there? When I was a manager for the Treaty Discussion Forum. We had talked about that. I was under Grant Chief Stan Beardy. We talked about creating a Treaty Commission office for Ontario. There was already one in Manitoba and Saskatchewan at the time. And I don't know what happened, but I think we found out that the Treaty Commissioner does not have any authority of any kind. It was sort of a recommendation power. That's all he had. Maybe that's why he didn't go through. But I think we should continue that and create a Treaty Commission office for Ontario. And I think we need to develop curriculums, teach it in school, not the treaty itself, but the treaty making process. Because when I was the students that were there, they were very, very surprised. They responded very well. You mean you guys were being lied to all this time? He said. They understood how to treat when I explained to them how it went, and there was no translation. A teacher came up saying, "Can I say a few words?" I said, "Sure." I'm a teacher. I work in a provincial school. My husband teaches in a First Nation school. Our salaries are like this. Mine's a lot higher than his. Why is that? She said. So they start to realize going on. I think we had more and more teachings of the treaty making process all over Treaty 9, our area. Then I think it's a starting point. It needs to be continuous. The reason we're back here again is that the Treaty Commission plans were making back in 2009, they stopped. They didn't continue on because the funding left. But we should keep trying to teach that. I'm going to keep teaching it at a personal note in the grade school level. That's where it just started. And I've been doing a lot of work for my people since I started, since I was a young man. Advice that my mom gave me. My mother was my friend, my advisor, my teacher. And she told me when I was a young man, he said,
Somebody can beat you up and hurt you physically, emotionally. But there is one that can only touch your soul, and that's the Creator. So you have a good fear for the Creator. He's the only one that can hurt your soul. Man can't do it. Next one, he said, go out, get an education, go to school, in a white man's school. When you come back, teach us what you learned. Don't ever use what you learned to hurt people. Use it to help people. Third thing, don't ever hit a woman, no matter what she does to you. I think I've graduated to 3 points from my mother. And she was also a residential school survivor, just why I got involved in this project. And I've also been an addiction counselor for about 40 years, addiction work. January the 5th of 2026 marks 43 years I've been free from alcohol and drugs. Most of my life. And I'm still teaching addictions. I do addiction workshops. My wife, she does the icebreakers and does the step dancing class part of it. We work as a team. And we do them in the coast of James Bay. And I think the grassroots level is where to begin. That's where we need to start. And I commend again once again Luke's department for holding this gathering together. And thank you for listening. Have a good day. We got you.
Thank you, Lawrence. So, it's getting around that time. When are you gonna have a draw? Okay? But anyway, I'd like to say that I enjoyed the past couple of days.
Talk in the mic.
I know these kind of discussions they're hard to control. When somebody wants to talk and you say, you notice I said 2 minutes? You notice I said 3 minutes? It's hard to do that. And maybe that's why they asked me to MC these meetings, because they think I have the heart and don't have the heart to say no to people. And it is a privilege to be able to partake in these discussions. And I too am, I like the others that's brought up in treaty. I'm gonna tell a story, a little short story, okay? I thought the world started in 1905. I honestly believe that. Everywhere I went, listened to people, 1905, 1905, 1905. And I thought that's when the world began. But after later on, I learned, no, that wasn't the case. But I think what I've learned and what you've taught me a lot. You've taught me that, especially ladies over here that that have a very strong sense of community and how that community involves itself, because that's what it's all about. We are Snobbiesky people. Maybe we have some difficulty understanding each other, but we're all from the same family. And what happens is that all that was said all that was said, so I think that I'm going to ask Deputy Grand Chief Madas Wabin to say the closing prayer. I mean, not the closing remarks, pardon me. But before I do that, I don't know how you guys want to proceed. You want to proceed with the draws first and then do the closing remarks? Oof. Do they draw first, then closing remarks? Okay. Okay. Spin. Brenda Fox. Red Sky. Come on. Yeah. So Mike, where did Mike go? Oh, there he is. Sorry. Yeah. Then you're gonna ask me, how big do I have to be? Okay, so for your closing remarks, then I'll do both of them.
What was what? Yeah, it's good. Yeah. Good day. Hey, good day. Mingues, Miswe, Murtagai steak, Nestagino, cabbage and dostame, cabbage canovastame, cabbage dostame tani tono. Mingues Miswe. Nestanina, Tepinue Mingues the ton. Nestanina Mingues, Kinanas Comitano Miswe. Miswe Omagai, Otagai steak. Nimenu Deni Gibeta Togok. And then the last communista, Egina Heban. Chigi, we tabe mit durch. Ja kumagat teetepään ei vihtamah, tän ei tentamah. Tän ei sinne se tohtamah, tän ei se paku sen muja. Ja kohuttu ke kona kantuen tau. Kiabet tuutsekä tekevan, kaisi papehtaman. Kiabet suma tuutsekä tekevan. I just thought I'd say a few words in the language first. I just want to say too that I think 1977 was a milestone for me in terms of starting out on my journey. Starting out in this journey in helping out in every which way we can to help our communities. For me, 1977, I was just leaving for high school. And as I was heading out, I happened to be at the Treaty 9 office in Timmins. And that's where I read that declaration, 1977 declaration. What an inspiration it was for me. As a young teenager, as a young person starting out. I did not have any knowledge of my history, of my or whatever traditions we may have pursued in the past.
I was not fully versed in the English language to know how to describe myself, how to tell who I was. I did not have that capacity in the English language. All I had was myself and my ability to speak my language, the Cree language, and what I lived and what I experienced and what I saw in life. So when I read that declaration, it really meant a lot. It lit a fire. And it set me on that journey. I spent a lot of time too in the library. Well, on a side note, I was by myself in high school as a indigenous student. I was the only one in that school, the high school. So having no friends, so what else? What else can you do? You had no devices, you had no internet back then, so the library was the only place to go. So I spent a lot of time in the library, reading up on just about our different tribes or just different books. The Unjust Society, I think, is one that sticks out the most. Chief Joseph, the Nez Perce. And I just started dabbling in other materials, other books, just different things. And then later on, it helped me continue my journey. I became a broadcaster for our indigenous language broadcast services, Wawate Communications. That too was a learning experience for me. I really learned a lot from there. And that's where I started getting involved with the territory, Treaty 9 territory, Anishinaabe Nation, as it came to be known after. 1985 is another milestone where that's when I started my political journey, or my education and getting to know our communities, getting to know the stories of our people, hearing the stories of our people, and translating during conferences. That's where I gained a lot of the knowledge, the stories, and that's how I got to know all of you. Most of the people I know here, most of the people there's not very many of us left that came from those days. But we're still here. And it's good to see that we still continue to do what we've always tried to do, and that is to advocate for our communities, speak for our communities. I want to go back to that declaration, 1977. Sadly, it became quiet after. It went silent. Nothing was done. Nothing was said. That was our treaty. That was the treaty that we're talking about. And not much, I can't say not much was done, but I think all I can say is silently the process continued, or work continued. But until the lawsuits came to play, the Robinson Huron, the cows and plows thing, all of a sudden we're interested again with the treaty. We want to talk about the treaty again. And I hope we can accept what we've been cautioned about. Let's be cautious. Let's not just jump into something that may do away or forever diminish what we have right now. Education is one way of creating that understanding, that awareness, not only for ourselves, for our youth, but also for mainstream society. I was having a conversation, and it's not the first conversation I had. And this is the same response I get when it comes to a residential school. Most often people will say from the mainstream that they weren't aware of it. They did not know about it. They didn't realize there was a treaty, or they didn't realize what had happened to us at residential school. So that's why I accept the suggestion that we need that education to create, to bridge that understanding, the knowledge, to share that knowledge, to share the experience. Not only for ourselves, but society in general. And hopefully in time, as we begin that education process with the young people of Canada, hopefully in time they will act accordingly, live up to the terms and expectations of the treaty. These last couple of days, I've heard a lot. I've listened to most of the presentations. And again, I'm very inspired again. I'm very inspired to that we're not done. We're not finished. Now we have new thoughts, new information. I want to acknowledge all the elders, all our knowledge keepers that carried the treaty story, or the treaty experience, or the understandings, what our people understood about it. And the diaries confirm that. The McMartin diaries, they confirm what our people understood and what they heard. And of course, it's not written in the written text. The written text was, like they said, it was prepared already. So the presentations again this morning were very interesting, very insightful. The Len Suji's presentation was very informative. And that's what I mean about it gives us, it lights that fire again. Now we have new information. Also, we have new strategy on a strategy to educate our young people, to empower them. That's what's missing, is that we need to empower our young people. We need to empower our young people so that they can be part of the evolution of this country, Ontario, especially Northern Ontario. We cannot continue to expect handouts. We need to be part of the solution, be part of the workforce. There's one thing I noticed over the years when it comes to mining, is the people who work at mining are people who work at mining. They're the silent ones, but they're happy. And they have been able to acquire whatever they want, whatever they need. They're quietly, happily making money. Nobody ever talks about that. Nobody ever invites them to speak. But that's what I've noticed over the years. The folks that go to work, they come home, and the benefits, you see that with their children, with their families. So these are just different points I'm just throwing out. I know Morris has left, so I'll be freely speaking. I'll say things about him too. Just kidding. No, I respect what he said. I respect what Morris had to say. And it's the frustration or I guess the realization that we need to do more. We need to do things together. We also need to separate the functions. Right now, as it works, Anishinaabe Nation is viewed as the top, the head office or whatever. As we speak right now, we're undergoing an exercise of what do you call it? We're looking at making changes to the governance structure. And that's currently being sought now, like people are being interviewed. How would we like to see it? How do we want to see our governance system? And it is clear, politics and administration, they need to be separate. Those are two different functions. In politics, we're advocates. That's what we said when we got elected to our home communities as chief or as councillors. We said we would speak, we would advocate. And meanwhile, our ban office ran the administrative affairs. But they got mixed up. They got intertwined. And that's why we struggle. We continue to struggle with that. So there's a lot of work that is yet to be done. And for myself, when I agreed to sign on for this role, I always believed that I was an advocate. I always believed that I would listen, or I would take part in the conversations. Couple of notes I made. The stuff that's going on in Alberta. For me, that's very what's inspiring about it is the fact that on social media you see academics talking about the treaty. The treaty is what binds the country together. Alberta did not exist. They don't have any privilege or right to say that we're going to separate. It's the treaty that binds the country together. So that that says a lot about what we're doing, what we're saying today about our treaty, how important it is, how we need to continue to work on it. I want to touch a little bit about what Chief Russell said yesterday about the treaty itself and what it means for us. It means it speaks it's about our livelihood, our sustenance, our economy. We need it to survive, I think is what he said. And when he said that, I remember my late dad. The one word he used when he was going out back on the land. They were asking him, "What are you doing? Where are you going?" And the word he used to describe what he was doing, why he was going out there, pointing to the land, he said, "Egoma ne dit atuspunatic, atuspunatic." In the language, it means that's my I don't know if I will get it right, but it describes that's our dinner table. That's where we eat from. And he was pointing to the land. And that's the word he used. That's how I survive. That's how I feed myself. That's how I feed my family. So I just wanted to share that too, because I just remembered how the way our people looked at the land. I just want to thank the staff, Andrew, Look. Now I'm forgetting names, but everybody else, all the staff for being here, for helping to coordinate the conference. I know it's a lot of work. I know coordinating travel is a lot of work. Booking accommodations and all that. There's so much that can be said, so much to say about this conversation. The treaty office. I would like to think we should work towards having a Treaty 9 office that would put a voice to our politics, that would speak to the expectations we have about the treaty, the understanding, the promises that were made to our people. You can't do that with a corporation. Corporation is different. Corporation, we have to be accountable, abide by terms, fiscal arrangements, and all that stuff. So you're not really an advocate under that umbrella. Under a Treaty 9 office, then you're representing the people. You're representing the voices of our people, of our nations, of our communities. So with that, I just want to say again, thank you. Adam, thank you for your words. Yagwamasiyon, Yagwamisik. Amy Westland continues to help us out. Who else? Our newfound family member here from Alberta. I did not know that, but she's from Port Albany. Last name Gillies. First time I met her. And welcome back, welcome home. Glad to have you working with us. Who else? Ronald Lehman, thank you on behalf of the conference. I just want to extend our appreciation for his words too. It's people like Ronald Lehman too that they started this journey from way back, like 40s, 50s, 60s. If it wasn't for them, I don't know where we would be today. But it's people like that, even going way back, like the books I was mentioning, The Unjust Society, all our people. We've been in this journey for a long time. Chief Joseph, running to save his people. We've been at this for a long time. And we're still at it. 2026. Nothing's changed. Kill the Indian policy is still in effect. So, okay, I don't want to go down that road, but I just want to say again, thank you, Chimingues. It'll help guide the work, and it will help us provide recommendations to the leadership, to the chiefs, and hopefully our community members too. That each community will provide that guidance, the recommendations on how we move forward with the with our treaty.
Thank you, Deputy Grand Chief Melvin. Okay, so at this time, I'd like to call on the walking bear drum group to do the closing, what do you call it, and then I'll do the closing prayer after that.